Yeah.
And once it is sub judice, I don't think it will be fair for me to, pass comments on it. Thank you.
Do you think that is you taught equity? Those who do equity, they say they must come with clean hands, or they should do what is also equitable.
If a matter is brought, we see the alacrity and enthusiasm of the Supreme Court to decide on it. And 2019 till yesterday, related matters, the same Supreme Court is not acting. Will you consider that as justice being done for the people of Ghana?
Well, Honorable, you again agree with me that equity follows the law.
Equity doesn't follow time.
Equity follows the law.
I'm almost done, and I should be concluding. The Honorable Suyene wanted to get your take on Article 20 of the Constitution, which I believe deals with the matter of compulsory acquisition of land and the right of persons. And my Lord, not you again, we want to be able to correct a system. Now, you have, for instance, when you take Bema Camp, just around Elwak area there, you find what is called agric mechanization, where you have those tractors parked. That land was taken by the state for a certain purpose. The land is not being used for that purpose. You hear that a certain person or persons are selling the land to themselves. Yet in a military zone like that, give it to the military or give it to the airport. But you hear that land, you won't give back to the original owner. You have not paid compensation. You just hear that the land is being sold out. Just where you have, Chairman, forgive me, not directly. I'm getting your take on Article 20, and I'll refer to the specific provision, where it says that the right of the person who granted you the land must be respected when it comes to taking a decision on the matter in the public interest. What is your take on this?
Say that in all cases, let us look at the law and apply the law.
It is brought to your attention that Ministry of Agric is selling agric mechanization lands around, in and out of airport, not given to original owners, not given to the Ghana military or armed forces, not given to the Ghana Airport Company. We can be assured of justice from you, my Lord. Is that the case?
We cannot do otherwise. It is only the law that we can apply.
And Chairman, I should be concluding with a comment on e-justice and illegal education. And again, fair to him, on e-justice, as I recall, even back in 2012, I was in the company of then Chief Justice Georgina Wood when we undertook study with the Judicial Council, including Lawyer Teki, to undertake the best electronic governance system in Turkey. The problem has been availability of resources to implement it. I mean, e-justice, when you talk about automation of the court, it should not be narrowed to the buildings in Accra. It should be possible that each morning the Chief Justice should be able to communicate with a judge in Wa or Lambosi if Ghana is properly connected. And I agree with you that even though, Chairman, you interjected at that time using Bekwai because you have internet. Maybe in Winneba the internet presence may not be as strong as Bekwai. But I do agree with you that e-justice is a phenomenon to go. And I think on legal education, Chairman, I can agree more with him that we should expand access by supporting them with infrastructure and investing heavily. With this, Mr. Chairman, I won't behave like the deputy leader. I wish you well, and I wish you every success.
Thank you, Honorable Chair.
Thank you. I hope probably the next time we we'll discuss the formula for disbursing the common fund. We will consider legal education. Now we have considered the judges, their residences. I visited their clubhouse. You'll love it. And that day, the members of parliament there said, now they won't drop the chamber again. Because every arm of government is taking care of its members. MPs are afraid to take care of their members. So, but my Lord Justice, I said, I've earlier referred to how you used to be intimidating for young lawyers when you were a magistrate at the Ashtown Court. I have a similar complaint from students that in the school, at the School of Law, they find you very intimidating. Yet you're saying that you have graduated from being the intimidating young magistrate. Now at the Court of Appeal you guide young people. How come at the law school you still intimidate them?
Thank you, Honorable Chair. You know, sometimes it's very surprising. There was a time I invited my own classmate who, at that time, he was a lawyer. That, he should just pay me a visit my chamber so we can have 1 or 2, chats. He said, "My lord, I'm afraid." And I asked why. He said, "Hey, you are a judge." I said, "But you are my mate." He said, No, my lord, you are a judge, you are a judge. So, you cannot prevent somebody from holding an opinion. You can smile at a student, you can do whatever you want to do just to make them feel comfortable, but you just can't prevent them from holding a certain view of you just because of the position you occupy. So I'll continue to smile with them, I'll continue to let them feel good, but I pray that they also have the courage to open up. Thank you.
I hope the students are listening that you're not as intimidating as you appear. They should make approaches to you. Very well. Now, I'm asking you a question I've asked all the Supreme Court judges, because they always come the same thing. If you had an occasion to discuss the jurisdiction of the Supreme Court, what would you ask that be taken away? What of their jurisdiction would you say, or what part of the Constitution dealing with the jurisdiction of the Supreme Court that you will recommend that be amended?
Thank you for the question. I will retain the jurisdictions which gives them the right to enforce the Constitution, the jurisdiction which gives them the right to interpret the Constitution, and then the jurisdiction which gives them the right to review, legislations. All the others are pushed down to the Court of Appeal.
You mean you will not let them hear appeals from the Court of Appeal?
Yes, appeals. For election petitions, I will let them retain it. But the appeals can be handled at the Court of Appeal. Documents which we think are of national security value can be handled at the Court of Appeal and some other jurisdictions. The chieftaincy matters can be handled at the Court of Appeal.
In that case, you would be then shifting the extra bedding, should I say so, to the Court of Appeal, because the Court of Appeal has the ability already. All your colleagues before you have said that appeals as of right in all civil and criminal matters is their challenge. What is your own view in respect of that particular one?
In fact, it is, thank you, Honorable Chair. It is a challenge. Because sometimes, and particularly as a trial judge, because of that provision, sometimes there is the need for you to stay proceedings, for litigants to exhaust their right up to the Supreme Court and then come back. And viewing it against what we all continue to lament, about, i.e. delay. If we can stop these things, I think it will go a long way to help us improve the delivery of justice. Thank you.
Okay. Did I hear you say in your opening remarks, your introduction, that when you are doing your service, you are attached to Mr. Koto?
Yes, Mr. Koto is chairman.
I rather thought you were with What is this senior? Gokubatin's firm?
Yes, Gokubatin. Asante Tanos.
Asante Tano and Co. Or did I get something wrong?
Well, it was my other colleague, Daniel Obin, who was with Asante Tano. Whilst Asante was with this lawyer.
Asante with this Sibo and.
Later on, he relocated to Nkoko with senior Ntiamwa. With Ntiamwa, rather.
Right. So you were not with Asante Tano and Co?
No, I was with.
I thought that was an error on your CV. Okay, very well. Okay, we thank you for attending upon the house to answer questions. You're discharged for now. You hear from us.
Thank you, Honorable Chair, and thank you to all honorable members. Thank you.
For all my colleague lawyers and judges who are here, we thank you for coming to support your friend and your colleague. You're mentioning names, but I can't mention all the names. So I recognize all of you. Thank you for coming to assist Lord Justice Asiedu. The Accra Bar President. Yes. I recognize you, Mr. President. Honourable members, we will suspend sitting and resume at. Is it 3:30? Okay. 3:30. Okay, 3:30. Right.
My honorable chair happened to be my mate. Yes. Yeah. And we were both in the Commonwealth on the same floor as well. Yes, yes, and the choristers. We were. Then, after having been called to the bar, I went to do my national service. I was assigned to Ministry of Local Government and seconded to Amansia East District Assembly, Ashanti Bekwai, which happened to be his hometown. Yes. Yes. And after my national service, I joined the AG's department as an assistant state attorney. I was posted to Cape Coast in 1990 November. Then 1994 I was promoted to state attorney and later transferred to Accra Drafting Division of the AG's department. I resigned my position 6 months thereafter and went to private practice in Cape Coast. I joined Michelle Barton and Partners and practiced there till the year 2000, when I joined the bench as a circuit court judge. I was posted to Achim Swedro. I was there for 5 years and transferred later to Takoradi, and I was a circuit judge in Takoradi for another 3 years. So it was in 2008 March that I was elevated to the High Court bench and posted to Wa High Court. I was there between 2008 to 2010. I think in the month of July I was transferred to Kumasi High Court. My lady here was appearing before me. Yes, and I was in Kumasi between 2010 and 2013, then subsequently transferred to Accra Commercial Court 2013. I served at the Commercial Court between 2013 till August 2020 when I was elevated to the Court of Appeal. And today I'm sitting here before you as a nominee for the Supreme Court. That is briefly what I will say about myself.
Very well, honored members, that's your nominee. He has already disclosed that he's my classmate.
So, Chairman, without further...
Another one is behind arm.
Since we won't ask Chairman to excuse himself, Chairman, just on the Honorable Justice George Kingsley Kumson, congratulations for your from the Court of Appeal to the Supreme Court. Is that right? That's the elevation President Nana Dankwa is recommending to Parliament.
Yes.
How long have you served on the Appeals Court? Thank you, Chair.
2 years.
You've been on the Appeal Court 2 years?
Yes.
Is it the case that you've met other judges at the Appeal Court in long standing who are still awaiting to be privileged as you are today?
Yes, Honorable Chair. I met some in the Court of Appeal, some I am senior to, but they were lucky to go to the Court of Appeal before me. Some are also my seniors. So the that.
You have suffered injustice, others who have benefited from injustice to you. Is that it? We are simply saying that promotion and appointment to the bench must be meritorious, and probably as was observed by Donna Blayerga, we may have to learn from other jurisdictions. South Africa just determined a new Chief Justice. It was publicly advertised and competitively determined, but given the architecture of our constitution, not your doing at all, but your CV again, page, the paragraph 2.5, 1967 to 1976, the Drum School, is that the name of your primary school and middle school combined?
Thank you. The name Drum School is derived from the fact that the school was established in a market. So I did my primary and middle school in a market.
What is called Drum School?
A Jom school, and a Jom school, and it has been corrupted to Jom School.
Okay, Chairman, we have taken note of that. And again on your CV, 1995, you worked as state attorney, is that right?
I started my career as a state attorney in 1990 to 95.
At where?
Cape Coast.
Cape Coast?
Yes.
Okay, Attorney General's Department?
Yes.
Okay. But if you come to paragraph 5.6 and paragraph 5.7, legal practice 1995, and then when you come, you now state the state attorneyship. My understanding, Chairman, is that you also did some drafting, is that right?
I was there for only 6 months, but
who was your superior then at the time?
Mrs. Ofori Boating.
You met Mrs. Ofori Boating, not Amwa, not Professor Azukrab.
Amwa is my mate. Mrs. Amwa is my mate. We entered the Ages Department together the same date.
Chairman is proudly saying that you are the mate. I'm wondering whether he should still be presiding whilst this emphasis is done. But, Chairman, if I still have your indulgence, my Lord, it's not for nothing that political theories establish respect for the co-equal organs of states. The executive headed by the President under Article 157, 158 of our Constitution, under Article 95 of the 1992 Constitution, and the Chief Justice under Article 144 thereabout. Are you concerned, as we are concerned in Parliament, that there is an attempt at what is largely described as a judicial encroachment on the powers and mandate of Parliament, given recent matters that have been brought before the Supreme Court and a determination made on those matters. Thank you, Chair.
Thank you, Mr. Chairman. If Honorable Member, the Majority Leader, can be specific in respect of the matter he is referring to. Oh, sorry. Honorable Minority Leader can be specific in respect of...
Justice, don't bother yourself. When we are done, we'll ask for a vote around this table. Chairman is here, and we'll see who is in the majority. You just walk in. We'll ask for a vote. Do you have more than 137 seats?
Out of order.
Chairman, so I'm still on the doctrine of separation of powers. Are you a true believer of it? Yes. What does that notion and this doctrine mean to you?
Thank you, Honorable Chair. Separation of powers requires the three arms of government in the first place to be independent, but they must work in coordination so that at all given time there will not be chaos in the democratic dispensation that we find ourselves.
So when you see the Supreme Court will review our standing orders, will you consider that as judicial encroachment?
Thank you, Honorable Chair. I am not privileged to the facts of the case, but what I will say is that depending upon the issues that were before Parliament, before the Supreme Court, a pronouncement might have been made. And that pronouncement made by the Supreme Court is the binding law now. Maybe in a given another scenario or circumstances, the court may be disposed of changing or shifting from that position. But as it is now, that is the position of the law. The Supreme Court has power under the Constitution to interpret and enforce the Constitution. Depending upon the constitutional issue that was placed before the Supreme Court, that decision might have been given.
So if Parliament, by the exercise of its mandate under Article 110, is asked that, and Chairman, with your indulgence, I need to quote verbatim, so that my Lord will respond appropriately. So I go to Constitutional Provision 110. Subject to the provisions of this Constitution, Parliament may, by standing orders, regulate its own procedure. May. So Parliament determines its own procedure. We decide that a certain rules and orders referred to as our standing orders shall govern our conduct in order that there is expeditious dealing with bills that appear before us. And the Supreme Court comes to tell us that no, go and expunge this. Don't you still consider that as amount to judicial interference in the exercise of the legislative authority of Parliament under Article 93? Thank you, Chair.
Thank you, Honorable Chair. The fact is that Parliament is said to be masters of their own rules. However, we are not operating a supremacy of Parliament. Both Parliament, the judiciary, and the executive, they are all subject to the Constitution. So with that, if a constitutional matter arises in respect of the way and manner a particular bill has been considered in Parliament, I believe that the Supreme Court, once it is placed before it, will have to look at the provisions in the Constitution and make a pronouncement whether the right thing was done or not.
I agree with you, Chairman. Parliament is not sovereign in our respect, but at least there is a semblance of separation of powers, even with the fusion under the 1992 Republican Constitution. But if a practice of Parliament matures up to 30 years, nobody saw anything wrong with it. Then all of a sudden the Supreme Court of Ghana says that this is wrong. Are you not sure these are some of the matters making the judiciary lose its respectability in the eyes of the Ghanaian public?
Honorable Chair, I would not subscribe to that opinion.
Are you concerned about the integrity of Ghana's judiciary, given the Afrobarometer report consistently saying that the judiciary, the police, parliament, and other institutions are corrupt?
Thank you, Honorable Chair. Issue of corruption is a national concern. It is not, I'm happy you are saying not the judiciary alone. Almost all public institutions in this country are perceived to be corrupt. I personally, I will ask myself, if all public institutions are corrupt, who corrupt these institutions? It is the people. So it is an issue that we should be dispassionate about and find means of redeeming the image of all public institutions, not the judiciary alone. However, in the judiciary, we have rules and procedures to deal with corruption. And I will urge the public, because we have a strong complaint unit, we have internal mechanism where some judges within the judiciary itself have been called before committees, and when they were found liable, they were dismissed. And nothing stops anybody with evidence of an officer of a court who has compromised himself to report for the matters to be gone into. Yes, it is sad that as a nation we've reached this level where almost every institution in this country, every public institution, is being classified as corrupt. We should also be mindful about the fact that these things affect the investor confidence in the country. So, yes, it's true. A prosecutor belongs to the police service, may decide to collect money from an accused person in the name of a judge. But it is deemed that the judge is corrupt when he has no idea about it. But that perception, when translated into reality, is very dangerous. Nobody disputes the fact that corruption exists in the judiciary, because there has been instances, some have been dismissed for corruption. Thank you.
Thank you very much. And Chairman, may I again refer the nominee? Justice, they say, justice delayed is justice denied. The predictability of the judiciary, particularly in Ghana, means a lot for the investor community and for people to have faith to want to do business in Ghana. Apart from the tortuous, cumbersome processes associated with our court, you have a case where a Ghanaian is awarded a mineral license under Article 268. He is told that the law process was completed because there was no parliamentary approval. A citizen of Ghana comes to the Supreme Court and says that there are other contracts, some not even affecting Ghanaians, but probably foreign companies who have the same mineral grant and rights. The Supreme Court does not seem to be interested in making a determination of the matter. Will you call that justice being done?
Honorable Chair, thank you. I am not privileged to the details of the issues you are talking about. But what I would say is that any case that is delayed in court have some ramifications for our judicial administration. The fact is that most of the delays emanate from the parties themselves, lawyers, the infrastructure in place, then logistics. For example, you go to a court, you fix a date for hearing, one lawyer is in court, the other is not in court, but with a letter asking for a date. the moment the judge insists that I am going on without a lawyer, allegation of corruption made against you. I have a personal experience in WA. It wasn't an issue of corruption, but an originating notice of motion was filed. That same day it was filed, a petition was written against me. And the petition was in the nature that I am being coerced by a brother of the respondent. When the motion was filed, a petition, I had no idea as to whether a process has been filed. I was then in Kumasi for a weekend. My registrar called me. This is what has happened. I said, you keep the letter when I come. I opened it and I saw that it was a petition. You understand? Some of these things occasion undue delay.
So, my lord, keep it there. So, mine is specific. You have a case where Exxon Cubic is subjected to a judicial decision because a Ghanaian has been granted mineral rights pursuant to Article 268. He is unable to seek parliamentary approval. That is set aside. Then a member of parliament decides to ask the Supreme Court that can we examine the nature of other similar contractual obligations in the country that have not also received parliamentary approval to get a judicial pronouncement on the matter since 2019. The matter is now called, is pending on, you will be a justice of the Superior Court. Will you presume this to be the administration of justice in a manner that is fair and impartial? Thank you, Chair.
Thank you, Honorable Chair. The fact is that I do not, sitting here, I do not know the circumstances for the delay. But what I would say is that, like you said, justice delayed is justice denied. But I cannot make any comment when I'm
My Lord, we can't hold you to it. So if 2019 a matter is filed before the Supreme Court, 19, 20, 21, 22, Ghana's Supreme Court, the issue has not even been listed for hearing. Anyway, Chairman, so that leaves me so that our colleague will come in. Galamsey has become a major issue for us. Our water bodies are polluted. We are not getting value for our gold resources. What will be your attitude to dealing with matters of Galamsey that may come before you, my Lord?
If I am affirmed or approved by the Honorable House, unless it is by way of appeal or a constitutional interpretation, I am wondering how a Galamsey issue will appear before the Supreme Court. But what my view is that, as a people, we have allowed this thing to happen.
Chairman, leave it there, my Lord. Assuming, anyway, that will be prejudicial. Assuming a certain son is convicted of Galamsey, and the Constitution provides that you provide both supervisory and appellate jurisdiction over criminal and civil matters, and the person is dissatisfied with the ruling, can the person come to the Supreme Court over the matter?
That's what he said.
Thank you, Honorable Chair. That is why I was saying earlier on that unless it is by way of an appeal or an interpretation or enforcement of the constitutional provision, I do not see how a Galamsey issue will arrive at the Supreme Court.
Very well. Ranking member usually warms up for everybody. Yes. The floor is open. The member who wishes to ask a question. Yes.
Congratulations, my Lord. Yes. Looking at your CV and page 5, you were once a state attorney, and just before you left the Attorney General's outfit and started your private practice, you were posted to serve at the Legislative Drafting Division. But soon after you left the Attorney General's department. What accounted for that? Is it because you didn't have any interest for legislative drafting?
Thank you, Honorable Chair. As a matter of fact, after I was promoted to State Attorney, the transfer came, and I came to Accra. That was my first time of being engaged in legislative drafting. I loved the courtroom so much. So when I came, I realized that I was confined to the office, not going anywhere. And I walked to the office of my boss and told her, "Ma'am, I'm cut for the courtroom. I can't sustain this being kept at the office all the time." At that time, she has proposed me to go and do my master's in the Caribbean, in legislative drafting. She did persuade me, but I was bent on being in the courtroom. That is why I had to tender my resignation and move back to Cape Coast to do legal practice.
Again, on your CV, I see at page 8, seminars, training programs and workshops. And on page 8, you attended a seminar for High Court judges on causes and matters affecting chieftaincy. And now, having also served as a High Court judge in Wa, I'm sure you are very conversant with the numerous chieftaincy litigation that once plagued the capital Wa, and aspects of chieftaincy related matters were brought before you for adjudication. Now, my lord, you know we have a separate court system for chieftaincy matters. So you start from the Regional House of Chiefs, the Judicial Committee, and then you proceed to the National House of Chiefs, Judiciary Committee. An appeal from the National House of Chiefs Judiciary Committee then lies before the Supreme Court. But the point is, most often, there are delays, inordinate delays with chieftaincy litigation. Some have blamed the problem on the very nature of the chieftaincy courts. 3 chiefs, sometimes 5 chiefs, and they are assisted by counsel. Question is, would you recommend the creation of specialized courts where judges would be trained on chieftaincy matters to handle chieftaincy litigation, as opposed to the current system that we have? You go to court, one chief is not well, on another occasion a second chief is taken ill or is unavailable because he's attending to some customary matters within his jurisdiction.
Thank you, Honorable Chair. The fact is that chieftaincy matters are the preserve of the institution itself. They have their customs and their norms. That is why I believe the framers of the Constitution gave the disposition of matters relating to chieftaincy to the chiefs themselves. Concerning delays, it is not with the chieftaincy institution and their matters only. In our ordinary courts, we've been complaining about delays. And until a time comes that we've been able to develop a system that can expedite, because if I look at recently during the vacation, when they did this trial online, more than 1,000 cases were disposed of, out of about 2,000 and something cases that were pending before the various judges who sat on the matters. You see expeditious hearing of matters. However, concerning delays, when a chief is sick, he's sick. When a chief has traveled, he has traveled. There's no way, even if you bring it to 3 judges sitting on a chieftaincy matter, the same problem will persist, because it is the chief who will come and testify. And when you receive information that that chief is indisposed, what will you do? You have no option than to adjourn the matter. So I think when we get to a stage where we can digitize most of our adjudication processes, maybe we will cross that path.
My Lord, going through your CV, no, I've not exhausted my questions yet. Yes, so going through your CV, my Lord, I can see that you, under paragraph 6.0, leadership, you were appointed as chairman of a 3-member ministerial committee of inquiry into the unfortunate occurrences at Ejura on the 2nd to 27th of July 2021. And your committee made certain recommendations and findings. Now, my question relates to one of your findings on the payment of compensation for the families of 2 deceased persons, Abdul Nasser Yusuf and Mutala Suraj Muhammad. And here you recommended that adequate compensation must be paid to the injured persons in addition to the deceased persons. Are you aware whether steps have been taken to comply with this key recommendation of your committee?
Thank you, Honorable Chair. In the first place, my responsibility on the committee came to its end when we submitted our reports. However, I've been following development thereafter, not because I am a member of any committee, because the committee does not exist any longer, but because I am a Ghanaian. I read in the news that the Attorney General has completed a process whereby some compensation has been offered to those persons who died and those who got injured. Whether or not that has materialized, I am not privy to.
Okay, now, my Lord, it's just a follow-up. With hindsight, would you have given them timelines within which to be compliant, given that in the past few months there have been some agitations by the affected persons on account that there have been delays or there is some inertia on the part of the implementing authorities in getting compensation paid, so that at least you can tie them to a certain time frame within which the recommendation is carried?
Thank you, Honorable Chair. I think this issue came up during our consideration as a committee, but the consensus was that we do not know what is in the kitty for us to be able to give timelines. And in any case, we were not to do the calculation within that short time. So we were unable to make recommendation as to how much is to be paid to, because before you can make such a recommendation, you should have done some assessment. The extent of injury, incapacity, percentage, and all that. And to take into consideration the fact that there is available funds, so that you can say that within 6 months they should be paid, within 1 month they should be paid. We discussed it, but the committee came to the conclusion that until those things are cleared, we cannot purport to give timelines, because there should be an assessment of how much each person is to be paid before timelines can be talked about.
My final question. My Lord, the committee you chaired was a ministerial committee, and of course you looked into the conduct of the security apparatus and how they can sometimes be abused, so to speak, by people in political positions, etc. Now, I have time without number for a commission of inquiry, an independent police complaints commission, which would have the mandate to inquire into matters of the kind that your committee sat on, so that from time to time, when there are abuses by the security apparatus of state, that body is already in existence. And this is the norm in many democratic states. I just want to find out from you, having chaired the ministerial committee, would you join me in recommending to policymakers to put in place such a commission, an independent police complaints commission, to look into civil abuses, etc.?
Thank you, Honorable Chair. I think if it was a case of only the police that were involved, I will support what you are saying. But this is a case, it was a joint military police operation. And we all know that each institution has its own rules and regulations. You cannot ask a military officer to appear before a police commission. So if we are considering the need to establish even such a commission, then it should be a joint military police commission. Because what took place that day, it wasn't the police per se that caused those injuries and the death. If you look at the committee's report, it was the military who were involved. You understand? So I think, yes, if it's only the police involved, yes, it would be good for a police commission to be in place. However, if it is a joint military police, then I think we will have serious problem with the implementation of their mandate.
Thank you, Mr. Chairman.
Thank you. Honorable Obiama.
Thank you, Mr. Chairman. Congratulations, Justice Kumsin.
Thank you.
I have a few questions for you. The first one is the interesting case of ADB. The interesting case of ADB. ADB, our great government.
Okay.
Against Osman Ali. Remember the case very well.
Very well.
It's with the usual publication that we see in the newspapers when persons leave employment and the employers put out notice that they are no more in their employment and that persons should not deal with them. Your minority position in that case sounds very interesting. What really is the whole issue about this particular one?
Thank you, Honorable Chair. What happened was that the gentleman who was the plaintiff in the matter happened to be employed by ADB, and he served ADB for more than 2 years and resigned his position. He tendered his resignation in July to take effect at the end of August. At the time that he resigned, he had some issues outstanding issues regarding his loan to sort it out with ADB. After everything was done, in the month of, I think he made the last payment in February, the following year. In March, ADB made a publication that he was no longer working with them, for which reason he does not have their mandate to represent them in any transaction. The gentleman saw that as defamatory and sued ADB in court, asking for various reliefs, including damages for defamation, special damages, and exemplary damages. The High Court entered judgment for him in part. That is to say, in respect of the defamation and the damages aspect, the High Court entered judgment. ADB appealed, and because it was a panel of 3, I was of the opinion that no, a publication of the truth is a defense and it's a justification. It can never be defamatory. The majority were of the view that it was defamatory. So I wrote my dissenting opinion. And that is what is before you. But I still hold the view that when a person publishes what is the truth, I cannot imagine how it can be defamatory. Because one of the cardinal principles or elements that a party should establish is that the publication is false. So once the plaintiff himself admitted in his evidence and in his pleadings that he resigned, and that does not have the mandate to represent the company, I do not see it as a falsity when it is published. Thank you.
Yes, thank you so much. So as a follow-up, what is the position of the law now?
Thank you, Honorable Chair. The position of the law in respect of what, if I may seek clarification?
Such publications.
Publications.
Such publications. Because you find institutions always publishing that so and so is no more in our employment and nobody should deal with them. And if the law is saying that you can sue because it's defamatory.
Thank you, Honorable Chair. The fact is that each case will have to be looked at its own context and its special circumstances. We cannot make it a blanket law. Defamation laws are there. However, before you conclude that something is defamatory of another, you must look at the circumstances of the case and the background from which that publication was made before you can conclude that it is defamatory. So we cannot make it a blanket check that the moment a publication is made, then it's defamatory, you sign, you go for damages.
My Lord, just a follow-up on what my learned and respected colleague tried to seek your views on. My Lord, we know as a matter of law that equity will normally not aid the indolent. And you've argued that circumstances of a particular case can lead to a judge making a determination in a certain manner. Don't you think that in exceptional circumstance of a banker having left the employ of a bank in a certain month, it is only appropriate for the bank or the employer to take immediate steps, if so to speak, it wants to put out the fact out there that this particular person is no more within our employ. But to wait 6 months after or 8 months after would now create, though upon that publication you wouldn't be publicizing or you wouldn't be publishing falsehood, you would be publishing what is factual. But then there will be an element of bad faith. Because that banker who has left your employ uses his image to get another employment. So my question to you is that, wouldn't it be appropriate to look at the timing, or that the employer would also have to be proactive so that an impression is not created as though it is aimed at tarnishing his reputation or creating a certain impression about him? Don't you think that in such exceptional circumstance, a claim of damages could lie?
Thank you, Honorable Chair. Like I said earlier on, when the man tendered his resignation, there were outstanding issues and there were communication between the employers and him. It was in February the following year that those outstanding issues were resolved. The next month, the publication was made. So to me, technically, insofar as there were outstanding issues that the parties were talking about and trying to resolve, time would have been frozen. Because when he cleared himself of all debts and all responsibilities to his employers, now he will be deemed as no longer having any interaction or interest with them, for which time started counting. I must say that that was one of the reasons I departed from the majority decision, because they were of the view that, like you are saying, the man tendered the resignation in July. The trial judge said it was 10 months later. When you do the calculation, it was a little more than 6 months to 7 months. But she did not take into consideration the fact that these matters were pending for which they were resolving. It was in February. Then the publication was done in March. So to me, technically, it was a reasonable time for them to do the publication. However, if an employer slept on its rights unduly, then we can be imputing bad faith into it. And we know that by the principles of innuendo, a person can be able to establish defamation and get damages.
So, my Lord, would you say that even though the judgment which has become the law is that such a publication is defamatory, this particular judgment should be confined to its circumstances, so long as the law, the law is confined to its facts and not of general application?
Yes, I believe every lawyer knows that every case that goes to court is determined on its own merit. The principles are there, but you look at the particular circumstances of each case and decide whether the application of the law with the evidence will lead to such a conclusion. Thank you.
Yes, Honorable, please continue.
Yes, thank you, Mr. Chairman. My Lord, let me ask you a general question now. You attained the age of 60 in May this year.
Yes.
All things being equal, you will spend 10 years at the Supreme Court.
Thank you, Honorable Chair. It will be less than 10 years.
Because of when you are being appointed.
Yes, I was appointed in February. No, to the bench for the first time in February. But my appointment to the Supreme Court, if I'm approved, I do not know when the swearing will take place, so I can't say when my appointment will take place.
So, just shy of 10 years, because obviously you'll be appointed this year. Yes, so let's say, I'm wishing you all the best. So let's say that for almost 10 years you'll be at the Supreme Court. Having been a lawyer for 33 years in private practice and on the bench from Circuit Court to Court of Appeal and now going to the Supreme Court, what do you think should be the way forward for the judicial system in Ghana? You maybe end up as Chief Justice. So we want to hear you as to how our judicial system should progress and how we can rub shoulders with the best in the world. Thank you.
Thank you, Honorable Chair. I believe the Honorable Member is becoming a prophet, so that if it is a prophecy, I can go and fast towards it. Yes, you see, in this century, almost every country is drifting to digitalization. And if we have to advance our system, we must begin to do a more effort in digitalizing our court systems. You know, with the exception of some few courts in the cities, maybe Accra, Kumasi, when you move hinterland and some areas, nothing is going on. Judges are still writing longhand. Court premises, and I remember when I was transferred briefly 2 weeks to Kita, I entered the judge's chamber, I was surprised. You know, the table, the chair that the judge sits on, they have they've cut a piece of foam and put it on it. In front of the chair was a bench. So I called the registrar. What is this? And he said, my lord, this is what we have been using all this while. So you can imagine if you have such facility in this time. Definitely it is going to affect the morale of any judge who is posted to such a place. So we should make it requires a lot of funding, but we have to make the effort to change how we resource the judiciary. And maybe I will propose to the Honorable House next time when our budget comes, you ensure that it is not cut, so that we can take up some of these logistics and what have you.
Chairman, is that the only reforms that you want?
Then also, I think we will have to get a second look at our rules of court. So many interlocutory matters. These are some of the reasons for the delays we have. You know, we introduced case management process, and in the list you have whether or not a party will be filing an amendment. the usual answer they give is when it becomes necessary. Some parties will wait till the last witness in the box, then they will file a motion for leave to amend. Having wasted so many months, then they come with amendment. If you refuse, I personally had an occasion to refuse an application of that nature. It went to appeal, to the Court of Appeal. It took 6 months, more than 6 months, before the appellate court gave a decision. We have to stay proceedings till, because the last witness was in the box and they filed the motion. I refuse. You can't proceed, because if you proceed, it means you can. So we suspended trial for more than 6 months before the decision came that they should amend. And they allowed it, and rather unfortunately for them, the amendment that they introduced rather nailed them, and they lost. You see, sometimes, yes. So I will propose that we have a second look at our rules of court. That is also an area that has been causing a lot of delays. Then I will also talk about, we should have in place a system of transfers, promotions. I am so, because look, between Circuit Court and High Court, I spent 20 years. Yes. 8 years at the Circuit, 12 years at the High Court. 20 years. Having practiced 10 years. So, if we do not have a system in place, some judges become disillusioned. So, these are some of the recommendations I, in my opinion, may help our judicial system. So that when a judge is coming to, a lawyer is coming to the bench, he knows that within the next 5-6 years, he will be moving to the next level. Within the next 3 years, he is going to the next level. So that it will be a standard practice. That is what,
my Lord, are you suggesting automatic promotion? Because I recall exactly what the late Chief Justice, I think Akufo-Addo, told a magistrate who went to him to complain about promotion. And he said, whatever you do, I get to hear. If you take your promotions into your pocket, don't come to me to ask to be promoted. So if a judge is taking his promotions into his pocket and is not delivering, should be a criterion for promoting him or her?
Thank you, Honorable Chair. Not necessarily long service. You see, but for every promotion, there are other factors that they consider. Your competency, your integrity, and other things. So that if you satisfy all the requirements, why not? But my point is that, look, somebody has been posted to maybe a court hinterland, and that is it. He will never see transfer to any city for him to develop himself to perform creditably. He is left there, no library facilities. The kind of even lawyers who go before him is an apology. So sometimes there is a need for yes, there is a need for judges to know that if I am being sent to, let's say, Aguna Nyakrom District Court, though I don't have a district court, we used to have, it was taken away. We are just praying that one day we will be given the district court again. You see, then he knows that if he performs creditably, within the next 4 years, he is due for transfer, and he is certain of the place or the region he will be going, so that he can plan ahead. Thank you.
Yes, next. All right, Lee, and then I'll come to you.
Thank you, Chairman. My Lord, congratulations.
Thank you.
You belong to Paradise Temple, I belong to Kingdom. So I will take you to a very important but vexatious issue. You're going on the Supreme Court. What should be your focus in situations where the issue at stake is at variance with your religious belief?
Thank you. Every human being in this world has a kind of belief, whether religious, traditional, or whatever. But I have been on the bench for 22 years. My religious beliefs has not interfered with my work. We work with the law, the rules, and for which reason when the evidence before me, if applied to the law, this is the conclusion. Irrespective of my religious belief, that is the conclusion I will go for. There is no way my religion affects my decisions in my determination of cases.
Assuming a madman rapes a young girl and the girl is less than 18 years and the family decides that for certain obvious reasons, because I believe that if a madman possibly the product will have some, and so they conduct an abortion and it's reported to the police and this is brought before you, what will be your reaction?
Thank you, Honorable Chair. In the first place, a mad person doesn't have any responsibility when it comes to crime. And if a mad person, by reason of rape, impregnates a girl, you know, our laws on abortion is such that it becomes an exception, and for which an abortion can be granted. But the fact is that it doesn't lie in the power of the family members to decide whether to abort or not. It is the duty of a medical staff, a doctor, for example, to determine whether it will be good for the health of to keep the pregnancy. Because, you know, in Ghana, we classify people as mad with a little mental issue. Some, it is maybe pure depression. And that is not... so we have different shades of a person being mad. Because a typical madman who sees a woman and have an erection, to me, has the senses working, and we should look at his mental faculties well.
Oh, Lord, with respect, if you may repeat that point and clarify.
You repeat anything? Yeah, I've ruled him out. We heard all that. Yeah. I have what you said. Please proceed.
Mr. Chair, with respect, I would take away the first part of my question. My Lord, with respect, clarify your point on the issue of the menstrual. What you are trying to say is that a madman may not have what it takes to commit such a crime. That is your position, and that is the law.
Yeah. Yes.
And therefore, if a supposed madman does otherwise, it means that the person has the necessary menstrual and therefore cannot go under that exception. I need you to clarify. What do you mean? What do you mean? By a madman would not have what it takes? Mr. My Lord, this is a very serious matter. My Lord, this is a very serious matter that you need to clarify. this is not law, but medical. So I need you to clarify whether madmen, my Lord, hold them, they are hormonal. When the mental faculty is disturbed, it also affects the hormones that would lead to they having that edge. Because, my Lord, this is a serious matter you are raising. No, my Lord, this is a serious matter you've raised of medical interest. And you haven't stated in your CV that you are an expert in that level. So, my Lord, clarify for us. Is it a medical opinion you are proffering to justify your position that a man ordinarily cannot have an erection? Is that your case, Mr. My Lord?
Thank you, Honorable Chair. The point I am making is that, you see, we have various forms of madmen. So when he used the word a madman, I wanted to put across that if we say a madman, it does not mean completely mad. Yes, the person might be suffering from a disease of the mind, depression, but has lucid moments and is capable of, when you walk by the street of Accra, you find a lot of people we classify as madmen. Some are not mad, but poverty has made them so. They pretend to be mad so that they can be begging for alms. So our classification of people as mad people is what I am looking at. So the fact that a person says, this is a madman, does not automatically mean that he is completely off. Because when a person's mind is completely destroyed by reason of a disease, you see, we are men. It takes a man to process certain things in the mind before you move to do an action. And if a person is completely off up here, I doubt if he can.
Very well, my Lord, let's proceed. Yes, your next question.
My next issue is also a very controversial issue. This is because you did your service in Asen District. I also did my service there. This issue of Queen Mothers being admitted to the National House of Chiefs, the Regional House, or the House of Chiefs. We've seen situation where you did your service. There was once a woman who was the chief, Mrs. Texan. There has been this issue, clamor that they also should have equal representation in the various houses of chiefs. And it become almost a vexatious issue. What is your personal opinion about this particular traditional, let me say, principle, which in these days of affirmative action?
Thank you, Honorable Chair. You see, behind me is, that's why you're asking. She is a chief, not a queen mother. You understand? And you see, when it comes to chieftaincy, each community has its own norms, rules, and traditions. So when you go to Fantiland, there are certain areas women can succeed the stool itself. It is whoever occupies the stool who is the chief. So once it is her turn to be installed as chief, whether she is a woman or a man, she is a chief. And if that stool should be at the traditional council or the regional house of chiefs, irrespective of the gender, the law says the occupant of these two is a member of the House of Chiefs. She must be admitted. But if you are looking at Queen Mothers as a group, then it is a different issue. Because why can't Queen Mothers be admitted? Because in any case, it is the Queen Mother who will nominate the chief.
My Lord, can't you leave it there? The Constitution says that that matter should be determined by the National House of Chiefs. Don't make any don't make any prejudicial movements to face you someday. Thank you. Very well. Honorable Tampuli.
Very grateful, Mr. Chairman. My Lord, I congratulate you on your nomination.
Thank you.
Now, mine is on the rules of natural justice. Specifically, nemo judes in causa sua. A person shall not be a judge in his own cause. Now, there is a long line of case law, about this particular, judicial principle. From Attorney General and Salah Kwashi Aidan versus Akufo-Addo, Ghana Bar Association versus Archer, Urban, and so on and so forth. But there's one particular one, which is Bilson against Rollins. Right? Now, in that particular matter, the petitioner, or let me say the appellant, Bilson raised some fundamental issues about the reason why the Chief Justice should not empanel, the panel. Now, the court made some distinction or maybe exception to the rule of, the application of the nemo judes in causa sua. One of which is that if the statute says that this person should chair or should preside over a matter, there's nothing that we can do about it. And then secondly, if the parties are aware of the disqualifying matter and still went ahead and then said that, okay, this is it, we know, but we still want you to, and so on and so forth. Now, I take you to the issue of the composition of the General Legal Council. The Chief Justice chairing, and then there are other three or so justices of the Supreme Court. Now, when a matter coming from the General Legal Council, is brought before the Supreme Court, chaired by the Chief Justice. Now, the rules of natural justice, I'm not sure how this particular one would apply, even though the statute says that the Chief Justice will chair. Is it not in keeping with best practices if we made somebody else to chair the General Legal Council, so that we can do the necessary amendment to the law, so that if the matter goes up to the Supreme Court, the Chief Justice will be seized properly with jurisdiction to seize on the matter? What's your take on that one?
Thank you, Honorable Chair. The fact is that, if I understand you well, you are saying that where it relates to matters of discipline, maybe the disciplinary committee is sitting on a matter, and by implication, the Chief Justice sitting on the disciplinary committee. Once it is so, it means that he cannot preside on the matter when it goes up, because he presided over the matter at the first instance. But the fact that the Chief Justice is the chairman of the General Legal Council does not necessarily mean that he should be a member of a disciplinary committee. But if the committee sits, takes a decision, and it goes on appeal, merely being a member of the General Legal Council will not disqualify the Chief Justice from the performance of his statutory duties. That is my take.
Mr. Chairman, I think that
I would let this slide. Even though I don't agree with you, but I would. I think my next question has to do with some best practice that I've observed, especially from other jurisdictions. For instance, in Nigeria, appointment to the Supreme Court has to take into consideration a certain balance of the personalities who would constitute the courts. Now, you need to have people with commercial law background. Some will come with customary law background. Indeed, some would have to come even with Sharia law background. Some would come with chieftaincy and so on and so forth. So you have an all-round court. Now, in our case, that consideration is not. I believe every judge comes to the bench with something. What do you come to the table with?
Thank you, Honorable Chair. If you look at my CV, you will see that I have gone through the mill. I started with the Attorney General's Department. I prosecuted murder cases and all manner of criminal matters. I have an experience in criminal law. I moved to private practice as a general practitioner, all manner of cases. I became a circuit court judge with varied jurisdiction. Came to the High Court and with similar jurisdictions I performed. I've been at the Court of Appeal. I am applying my experience that I have gathered over the years, and if I am approved, why not? The experience I've gathered, 22 years on the bench, can be brought to bear at the Supreme Court. Thank you.
All right, then the first female voice, please. Let me hear her.
Thank you, Mr. Chairman. Congratulations, Your Lordship, on your nomination.
Thank you.
Just want to ask a question. It's a bit of a social question. And your CV really transferred, and you really moved around the country. I see there's some Cape Coast, there's some Wa, and then Kumasi, and then Eastern Region, and then back in Accra, and you've crisscrossed the country quite a bit. Tell me, what does this do to family stability? And this is also in generalizing it with the public service and the whole concept of transfers and stability of families and all that.
Thank you, Honorable Chair. The fact is that once a person decides to join the public service, then you should have considered these matters, because if the work that you are seeking to join involves transfers, then you should make preparation towards some of these things. Yes, I'm the type I like transfers. It helps me to learn different cultures, sample different kinds of food, and meet new friends. You know, it was in Wa that I met Honorable Agaga when he appeared before me. But for that occasion, I wouldn't have met him. Yes. You see, so transfers are good. Personally, I do not see anything. When I was in Wa, for example, my wife was in Kumasi. So the children were schooling there. Whilst I journeyed from Wa, weekends I'll come to Kumasi. Then Sunday I'll go back to Wa. So there wasn't much destabilization in the family. Yes, it is unpleasant, but once you decide that you want to be a public servant, you should have considered transfers and make contingency arrangements for you to have a successful career as a public servant. Thank you.
My Lord, so what is your advice to the young men who are receiving postings for national service, and all of them want to be in Accra. What advice have you for them today? Because the postings are ongoing. I want you to
please, when we leave here, we'll arrange for you to advise him. But the young man, he will give them advice, but on this platform, please, let's speak to his, yes.
Thank you, Mr. Chair. Your Lordship, there's a publication about which complains about the delay that a Kaka's family unhappy with delays in murder trial of killing. Now, what is your view on, after you may have successfully chaired the committee, come out with the findings, issued the report, submitted the report, and yet these delays happen, and then doesn't make you seem like your work is either half done or your work has been ineffective? And then after that, is there a system of perhaps evaluation of your own reports and work that you're supposed to have done? Because then it becomes a blight on, it becomes like a dot on the, it's almost like something is not complete, because the family will not get closure. You would also realize that your weeks of sittings are not really inconclusive. Tell us about that. Thank you.
Thank you, Honorable Chair. As a matter of fact, our mandate as a committee ended when we submitted our report. What happens thereafter, we have no control. Maybe reading in the newspapers, development from the report, there is nothing that we will be called for, because we were mandated to investigate and make recommendations. Once we did that, our mandate ended. If there is a trial going on, that is a criminal matter, which has nothing to do with our report. That is a police investigation, and we all know in this country delays in prosecution of cases, the causes. So it is not maybe that case alone, and I do not see it as a blot or a dent on the report that we issued. Our mandate ended immediately. Thank you.
So my last question, still on this. So do you think, as you are now possibly being represented, you're going to represent at the top, at the apex court, the Supreme Court, do you think it is time for some adjustments or some reorientation or reconfiguration? Because you can issue a report, submit it. We have a system of what we call evaluation, because after the report has been submitted and if nothing is done about it, then it's just a waste of everybody's time. And like I said, the people still do not get the closure. Should there be a system, an evaluation system within the judiciary system that will help people, that in case maybe something has been submitted and then after a while action is not taken, what next? Do you subscribe to that?
Thank you, Honorable Chair. You see, one thing I have observed in this country is that we do not make use of our laws. Where a public officer has a duty to perform and is not performing it, we have mandamus. You can go to court to compel the performance of a duty, but each case will be determined on its own merit. But as a people, we like to talk about matters, but we don't want to act on it. Our report has been issued, we have submitted it, and our work is done. Whatever happens thereafter, the committee is no longer in place. And I cannot purport to sit here as representing a committee, because no committee exists now. Thank you.
All right. Yeah.
Chairman, just one little follow-up. Now, you chaired a committee. The Constitution also provides an opportunity for the President to probably have chosen the option of a commission of inquiry. Between your committee and commission of inquiry, and what you probably came across investigating Ejura, what would have been your line of recommendation? The committee, or you think that a commission of inquiry would have done a better job? Thank you, Chair.
Thank you, Honorable Chair. The fact is that the decision to either appoint a committee or a commission vests with the President. And insofar as he exercised his discretion to go for a committee, that is a fact-finding committee, I cannot fault it because I do not know and I'm not privy to the circumstances why that decision was made. A committee has its own ramifications. Inquiry also has its own. So it is up to the appointing authority to decide which one to go for. So sitting here, I do not know what went into that decision to appoint a committee instead of a commission. Thank you.
Eric. Mr. Chairman. Mr. Chairman, after me, Honorable Ahi will continue.
Why do you determine?
No, he said he's having two questions, so I wanted to crave the indulgence of Mr. Chairman to allow Honorable Ahi to follow me immediately because the arrangement is that he will do some follow-ups. Mr. Chairman, my first question has to do with the independence of the judiciary. The independence of the judiciary. In order for a judge to make fair decisions, they must be independent. This is always depicted in the metaphor of blind justice. A judge's decision must not be influenced by anything other than the law and the arguments presented in court. Thus, the 1992 Constitution provides adequate mechanisms to ensure that the judge, and in the case of the Supreme Court, the justice is insulated from political manipulation in Ghana.
Thank you, Honorable Chair. Sitting here, I have not yet been appointed as a Supreme Court judge. So I am not privy of any political manipulations. So it is very difficult for me to answer specifically. But I will assure you that the independence of the judiciary is rare. Yes, there are occasions where some persons may be compromised, for which nobody can deny. We have had situations in this country where judges have been dismissed for such behavior. But I can say on authority that the judiciary is independent unless the contrary is proved. But I do not know of any political influence. Because the fact is that this country, politicians will come and go. So for how long are we going to sit down for the judiciary to be accused that politicians are manipulating? Politicians are manipulating. Personally, I do not see any manipulation anywhere. Unless evidence is shown me, then I can change my thoughts about that.
Mr. Chairman, my second question is that there is this argument that depending on the executive for resources to finance the activities of the judiciary and the legislature makes them dependent on the executive. And some people advocate that there should be some kind of financial autonomy granted to these two arms of government so that they can independently perform their constitutional duties. Oh, you are describing this as whose theory? What is your opinion on this important matter?
Thank you, Honorable Chair. You see, in this country, the consolidated fund is where most of our funding comes from. As if I take the judiciary, I cannot speak for the legislature. Our funding basically comes from the consolidated fund. And the Chief Justice or the Judicial Secretary is not a signatory to the consolidated fund. I do not know if the Speaker is. But however, insofar as the consolidated fund is in the hands of the executive, we will forever be dependent on the executive for our funding, both the legislature and the judiciary. So we have to do with it, because there is no way Parliament will allow judiciary to keep all the revenue that we make so as to fund ourselves. When Parliament is ready to do that, then I think we can achieve that autonomy that we are all dreaming about.
Chairman, Honorable Eric, let me have a bite of your pie at this moment. What the Honorable Eric is seeking to establish is that, yes, consolidated fund, a creature of the 1992 Constitution, which provides that all public monies are deposited in the consolidated fund. But if you read Article 179 well, the second leg of it, which deals with the judiciary budget, and Chairman, with your indulgence, we can go to it. It says that when the judiciary submits its budget, it kind of sits with the language that the executive shouldn't have so much to do with it in terms of what he politely didn't use, budget cuts. I heard Mr. Chairman telling me that even Parliament, which is supposed to be constitutionally the protector of the public purse, holding a calabash begging a minister for finance on daily basis as to whether they have releases or not. What our colleague is seeking is to say that can't we change our legal framework so that January, February, March releases meant for the judiciary for your effective functioning is made available to you. Parliament in December, January, February, March, your releases, whether item 1, 2, 3 is made available. Do you share that position?
Thank you, Honorable Chair. I subscribe to that position, because the fact is that there are times certain allowances will delay as much as 10 months. And I believe if we can put in place measures to ensure that financial release to the judicial service to run the organization is done on time, I'll be happy. So I subscribe to that opinion.
Chairman, just related to it, if you recall, under her leadership, Georgina Wood, that's when we had this strong advocacy supporting that the judiciary be allowed to retain a portion of your IGF. There was a conflict which ensued, and you had judicial workers embark on a strike action, maybe because of 8.6 million Ghana cedis. Yet the judiciary had over 60 million sitting in your account. But because you had no power to touch the IGF, you saw the conflict rage on. There is a school of thought which thinks that we should even increase your retention additional. To what percentage do you subscribe to? Thank you.
I will subscribe to 100%.
Yeah, very good. Are you done, or you have one more?
Question. The chair, I want to ask my last question, which is very, very important. Mr. Chairman, in recent times, there have been discussions on ex gratia, and normally the discussion is limited to payment of ex gratia to politicians, specifically members of parliament. Now we know under Article 71, Supreme Court justices also take ex gratia. Yes, justices of the Superior Court of Judicature, the Auditor General, and several other people are all mentioned here. My Lord, what is your opinion on the payment of ex gratia?
Honorable Chair, I know the honorable member wants to land me in trouble. Yes, the fact is that judiciary, the members, it is only when they retire. We do not take ex gratia until you retire, that your emoluments are paid. What people call as ex gratia to the judicial staff, that is the judges, it's more or less arrears of salaries when salaries are increased at the end of the term of a sitting president. A committee is set and salaries are adjusted. Then there is the need for arrears to be paid. But no judge takes ex gratia until you retire. That is why I said he wants to land me in trouble. And now that I am before you, I decline to comment on it.
Yes, there were one before.
Thank you very much. Congratulations, my lord.
Thank you.
I realize you love soccer and wrestling.
Yes.
You went to Winneba Secondary School.
Yes.
Okay, my lord, let me take you to sports, since you love soccer. And national team will be going to the World Cup. What you just want to take your mind off legal matters for now, because that is your domain. What has been some of the challenges of our sports development as a country, in your view, of our sports development as a country, in your view?
Thank you, Honorable Chair. In my view, our biggest challenge is our inability to put in place a sports policy. You see that anytime there is a change in government, the policy changes. But if we can develop for ourselves a policy for sports, then I think whoever becomes the sports minister will be bound by that policy to ensure that it is implemented. In that way, we can make a headway. But we are fond of doing ad hoc things. That is our bane. Thank you.
Nilante is not here, so I won't proceed. Osebonso is here. Okay. My lord, on your CV, paragraph 6.0 on leadership, sub 3 and 4. Member, Church Council, ICGC, Paradise Temple, 2, Domi, February 2022 to date. President, Men's Ministry, ICGC, Paradise Temple, Domi Pillar 2, September 2019 to February 2022. Serious man of God. I'm sure you speak in tongues.
Certainly.
My Lord, the churches lately have become, my view, let me put it this way, are wearing two hats. Some are investing in schools, some are investing in hospitals, some are investing in other commercial ventures. But most of them are registered under Act 922 as charities and companies guarantee. Would you advocate for some form of taxation, some of these religious bodies that have gone or ventured into these areas. Thank you.
Thank you, Honorable Chair. In the first place, our laws should be looked at. If the law is that charities are not to be taxed, that is where we have to look at. But if we want to see the commercial aspect of it, then insofar as a person is doing a commercial business, they are bound to pay tax. And I believe churches who engage themselves in commercial activities, typical commercial activities, if we can do something about our laws and ask them to pay taxes, why not? Because the fact is that from these taxes that we use to develop the nation, and raking in more money will be beneficial to the entire nation. So I will not say that it is a bad practice to allow charities not to pay tax or to pay tax. But if the laws can be looked at and we find it necessary as a nation to want to tax commercial ventures being undertaken by these religious institutions, I think I will support it. Thank you.
My Lord, thank you very much for your response. But let's look at issues on press freedom and independence of the media. I'm wondering if you've suffered any social media attacks on your person. Most of the lawyers are saying you have to be nice to them when they appear before you, though. My Lord, the media landscape has grown. We used to listen to only GTV and Radio Ghana. Now you have over 500 radio stations. Social media is the order of the day. Today you are cartoon here. Tomorrow there is an online TV dealing with innocent people doubling money, as it were, and all sorts of things are happening within the media landscape. I know you are a very disciplined person, having followed you for some time. What do you think must be the solution to some of these challenges we are facing within the overgrown media landscape? I know you are not in favor of censorship, but let's hear your thoughts. Thank you, Chairman. That's the end of my question.
Thank you, Honorable Chair. The fact is that media pluralism is good for our democracy. What we need to do is to ensure that the National Media Commission is empowered enough to sanction this erring media, because we are now drifting towards an irresponsible media. People, some, I would say, don't cross-check their facts. They put it out there, want the whole world to believe that that is the truth. Yes, I am an advocate of media freedom, freedom of expression, and we should always ensure the safety of journalists. However, freedom goes with responsibilities, and there is nothing like a limitless freedom anywhere. If you look at Article 41 and 164, you will see that there are some limitations that have been provided for. Yes. So, in my opinion, we should empower the National Media Commission for it to be able to bite. One day, the media will run all of us down. Because so much, the reason is that, we have citizen journalists. They are not trained, but they are performing duties of journalists. Somebody takes his phone, he's at the scene of an event and live broadcast, without regard to the rights of others. When they are taken to court for defamation, you will find the same media crying wolf, that when court award whatever, we are trying to destroy the media. No. Media freedom does not mean media irresponsibility. I think the National Media Commission should be given more powers to sanction erring personnel of the media. Thank you.
All right. So you need first, I'll come to you. Hello.
Thank you very much, Mr. Chairman. Congratulations, Honorable Nominee.
Thank you.
On your nomination. My first question, how many times have you been a subject of disciplinary inquiry, and what were the issues?
Thank you. For the 22 years that I have been on the bench, I have never been before or having been dragged to any disciplinary proceedings. Thank you.
What about the petition you referred to earlier?
Yes, you see, the petition was filed at the time the motion was filed. It was referred to the... She wrote to me for my comment. And my comment was that, look, the motion was filed the very day the petition was filed. And I had no idea about the case itself. It had not been put before me for somebody to sit down and even think that I'm being pressured.
Doesn't that qualify as a disciplinary inquiry?
No. You see, when the petition is filed, they ask for your comment. Then, if they are not satisfied, then they will constitute a committee to go into it. But this is a matter, my comment went, and they realized that the purpose of the petition was to prevent me from hearing the matter, because it was for a prohibition. And once I was the only High Court judge in WA, it means that if I am not sitting on it, by the time another judge is asked to come the proceeding, the festival will be over, and that chief can't be part of the festivities. That was the intention. Thank you.
Well, my next question, let me take you back to the committee that you chaired on the ministerial committee on the Ejura shooting. I have read the report so many times, and if you permit me, I'll go over some of the things that I find interesting before I pose a couple of questions on that. So you have Sadia Husseini's witness as a witness, and Sadia Husseini, according to the entire report, made two statements. One to the police before the committee was set up. In that statement to the police, she spoke of seeing two men run from the scene and two sticks at the scene. Before the committee, her story is different. She talks about a certain Baba Idi that she saw dragging the unconscious body of Kaka. The police DCOP, David Ajiman, in his testimony admits that indeed they found two sticks, one blood-stained, on the scene. He also admits that Sadia Husseini had made a statement earlier. You have then you have Husseini Mohammed. the two seem to corroborate the story of Sadia Husseini before the committee, but not the story that she initially gave to the police, which the police somewhat confirms when they say that they found 2 sticks. Now, I listened to the 2 stories, and I'm wondering, at what point did, if it was Babaidi, who, okay, maybe I should move on to ask the questions at this point. The questions I have after all of this is, Munira Al-Hassan says that at a point she bumped into somebody when she came out, and then that somebody becomes Babaidi. Sadia Husseini says the light was on, and then it later went off. So my question is, what happened to the light? The committee doesn't answer it. Who put it off? Was it a general lights off? Was it put off by somebody? What happened? The committee didn't answer that. The committee didn't seek to find out. Who were handling the 2 sticks that the DCOP says they found on the scene? Was it Kaka holding one? Was it Babaidi holding another? Was it Babaidi holding both sticks and still pulling Kaka on the floor? The committee's report don't seem to answer this. Why did your committee, it seems to me, ignore Sadia's first statement to the police and highlighted the narration before the committee, which was materially different from the one that she presented to the police?
Thank you, Honorable Chair. Until you are now telling me, I am not privy of the fact that Sadia had made a statement to the police. The fact is that when she came, it is the story that she told us, that we worked with. Whether or not some statement has been given to the police was not before us. And that statement was not tendered before the committee. So I'm surprised that you are alluding to something that happened at the police station as if it happened before the committee. The committee's evidence that we received, they are all intact. They are there with the Ministry of Interior. We submitted everything. There is nowhere before the committee that the statement that the made at the police station came up. And we see the committee was a fact-finding one. We did not seek to cross-examine the witnesses as if they are in the court of law. Because I have been a prosecutor for 5 years. I can do effective cross-examination. And if we had sought to do that, and our secretary who was conducting the cross-examination is also a principal state attorney. So if we had sought to undertake cross-examination properly so-called, definitely it would have been a different ballgame. But we tried to assist the witnesses for them to tell their own stories by asking 1 or 2 questions. That is why you saw the cross-examination that way. Sadia, in her evidence, never informed the panel that she had made another statement to the police, and nobody brought that to the attention of the committee that a contradictory statement has been made by her at the police station for our attention. Thank you.
Okay, Mr. Chairman, that's quite interesting, but I will move on, except to just say that in the report, like I indicated, I've read it so many times. In fact, DCOP David Ajiman, who appeared before the committee, in his testimony, spoke of the statements that were collected from Sadia, which led to the arrest of Anyas and Husseini Al-Hassan. It is in that report, but I'll move on, Mr. Chairman. well, but he spoke about it. I'll just move on. Now, to your conclusion in that report, you concluded, even though none of the accused persons appeared before your committee, that Kaka's death may have been as a result of a family feud and not as a result of his activism. Now, none of the accused persons, not Hussein Al-Hassan, not Anyas, who were initially arrested based on the initial statements the police picked from the crime scene, appeared before your committee. Kaka's brother, Baba Idi, did not appear before the committee. Yet, your conclusion seemed to have pronounced Baba Idi guilty, because you allude to the fact that his death, Kaka's death, may have been as a result of a family feud and not his activism. Don't you find that a miscarriage of justice, unfair as far as the rules of fair trial is concerned?
Honorable Chair, thank you. You see, we were a fact-finding committee. Our second mandate, if Honorable Chair will permit me, I'll read page 2 of our report. The second mandate says, inquire into any matter the committee considers incidental or reasonably related to the cause of the events and the associated deaths and injuries. That was the second mandate. Some evidence was led in respect of the death of Kaka. They were contradictory to each other. Knowing very well that the police were conducting investigations, we decided not to make our conclusion on the death of Kaka a final one. That is why we use probabilities. Well, you know, in criminal law, we don't use probabilities. It is reasonable doubt, beyond reasonable doubt. That is the standard. We use probability because we were of the knowledge of the investigation going on, and the fact that what was presented to us might have not been the entire evidence in respect of Kaka's death. So we were mindful of the choice of words. So we said, in respect of the evidence given to us, one was speculative. The one which was an eyewitness account, we couldn't have known that some different set of evidence or statement has been given to the police. In respect of this evidence, we are of the view that his death might have been probably a family feud. And in criminal law, the lawyers will tell you that when it comes to guilt, it is not a case of probability, because you can never add up thousands or millions of probabilities to secure a conviction. Thank you.
Mr. Chairman, I'll leave it here. Thank you.
Yes, Honorable.
Thank you very much, Mr. Chairman. Mr. Chairman, the Supreme Court of Ghana recently ruled that birth certificates cannot be used as a proof of citizenship for one to have his name on the electoral roll or register. What then is the relevance of the Ghana's birth certificate if it cannot be used to authenticate one's nationality?
Thank you. in the first place, I would say that the decision of the Supreme Court on this matter, until vacated by itself, is the position of the law. However, if you ask me my personal view, which has nothing to do with that decision, is that when you look upon the face of a birth certificate, what do you find? You see a name.
High Court rules on what do you call it? Witness statement, which I think it's good. I've always had the feeling that if a permanent judge may be appointed aside the council, if the court will be making a permanent judge appointed for the chief to sit around him like a size sort of, I think that will work. And
a member or the chair of the disciplinary committee of the FA in the Volta region.
And I'm still serving, sir.
You are still. Voradep is gone.
Agbozoma Rivers is gone. Whole Sunset. So, Volta region, soccer is lacking behind, I believe. So, what were you looking into in terms of disciplinary matters? Where are the clubs?
Mr. Chairman, Mr. Chairman, thank you very much for the question. The clubs are there, except that they lack funding in order to attract or to develop new talents. We need a lot of investment into soccer, and because I have the feeling that soccer can reduce, can make a lot of the young ones develop their talents, and soccer is still a recreation. When you look at what soccer is within the definition of the assembly rules, soccer is still a recreation, whilst others have turned into a huge business where a player could be bought at over 200 million pounds. I believe some of the salaries being taken by some of the players, if some of us here those salaries for 3 weeks, most of us may go into retirement. So there's a need for huge investment into soccer, especially, which is the passion of the people. We have to invest into it and give tax breaks to those funding the soccer.
Chairman, my last question. Your referees, you have my Lord the Chief Justice, and one of the most respected justices of the Supreme Court, Justice Jones Victor Maolom Doche, whom you served as a pupil, I'm sure, and became the head of chambers. How has he impacted your life and as a career, a practitioner, and now a justice of the High Court? Mr. Chairman, thank you.
Mr. Chairman, there's a lot. If I want to talk about Justice Jones Maolom Doche, and then I may have to need a whole day, but he's impacted me a lot. In actual fact, when I was in the trenches, I was in the gutter with nobody, he actually picked me up. My form to go to the university, he bought it, and after he bought it, he saw to it that I went to the university. So it's if I want to talk about him, then I may have to write a whole book for reading. He's the mainstay of my life, and up to today, he still gives me money. Thank you. Thank you.
Honorable Elizabeth Ajare.
Thank you very much, Honorable Chair. Congratulations, my Lord.
Thank you, Madam Mr. Chair.
My Lord, a quick look at Article 14.3 3 of the 1992 Constitution. Honorable Chair, with your permission, I read.
14.
A person who is arrested, restricted, or detained, I'll skip A and do B, upon reasonable suspicion of a having committed or being about to commit a criminal offense under the laws of Ghana, and who is not released, shall be brought before a court within 48 hours after the arrest, restriction, or detention. This article does not lend itself to any interpretation because it is so clear. Yet, policemen arrest people on Friday and wait till Monday before they bring them before a court of competent jurisdiction. What is your take on this?
I believe that is wrong, and it's an infringement on the rights of the individual, constitutional rights of the individual. That is wrong, and measures should be taken to talk to the police. We should bring the police in to understand that the whole constitution, the bedrock, is the liberty of the individual. This is what I have to say.
My next one, M.K. Gandhi, he says, an eye for an eye will leave everybody blind. There are two schools of thought. One school says, once a person is committed for murder, the person must face death. Another school is of the opinion that, like True Scott, a Canadian who was convicted for 48 years, incarcerated for 48 years because he was convicted of murder. Later, evidence came to show that he was after all innocent and he was released. People are of the opinion that because judges are human beings and may make mistakes, or better still, at the time of giving a judgment, evidence will not be enough to exonerate an accused person. Death penalty should be taken off our books. What is your take on this one?
Mr. Chairman, thank you very much. If you permit me, I'll give some few history as to why the death penalty is still on our statute book. I recall that in 1971 and 1977, the UN passed a resolution urging member states to do away with the death penalty. In 1989, they proceeded and went further and passed another resolution, this time asking members to completely eradicate death penalty, and they came under the second optional rules under the political and civil right. What I know is that Ghana voted for all these resolutions. But 3 years after, that is from 1989 to 1992, then we enacted for ourselves this constitution, and you will see that we have retained the provisions to keep the death penalty. Well, and finally, this matter came before a case, Dexter Johnson, that is the Republic, where it's a 4-1 decision, where the Supreme Court said, well, it's on our statute book, it is not unconstitutional. Now, what one of the judges, my mentor Justice Doche, recommended is that we should be able to create degrees of murder, maybe a first degree, second degree, aggravated murder, so that we apportion sanctions, maybe sentences, not so that we remove, so that this blanket situation where with this murder everybody is murdered, we should have these, what do you call it, degrees of murder and apportion. And that, for me, is no longer for the judiciary to think about this, for the political authorities like these honorable members to take up and bring it up and have it removed or do what we are asking. This is my take on it.
My Lord, I am saying your own take on it, because if there is a private member motion, you know, for example, that there is stakeholder consultation. I'm sure we want to say that Honorable Ernest, when he appeared before the appointment committee, even recommended that death penalty should be off our books. Even recommended that it should stay in our books. So I want your opinion on death penalty. That's what.
Honorable Chair, thank you very much. I, as a person, let me put it this way, as a judge sitting, when I try a case and it's a death penalty to be imposed, I have no option, I will impose it. But personally, I don't think, and I share the views of all these people saying that people should not be murdered or be killed because there could be mistakes done by sometimes the witnesses that are brought even may have issues, and so I don't believe personally in the death penalty. Thank you.
Thank you. Well, leave that to us. If we want to change it as a country, we will change it. But until we change it, apply the law as it is.
Thank you.
Now you have the floor. When you finish, you can add your follow-up.
Very well. Thank you very much, Mr. Chairman. My Lord, I congratulate you on your nomination. So as a follow-up to the question posed to you by my colleague, now I want to take your mind to the case of our Republic versus Dua. I believe it's 1984. And that appears to be the last time the death sentence was applied in Ghana. Now the case, the facts of the case, let me see whether the facts of the case would, give you a change of mind, if you remember. Now, the accused person committed the act, I believe, at a flat at Kolebu, and left the victim in the apartment for a couple of days until a pungent smell started emanating from the place. Now, one of the witnesses in the case was his uncle. After he had committed the act, he picked their small daughter to his uncle and told the uncle that Mekumagi, I've killed Agi. And the matter went to court. He was convicted. He appealed all the way. Now it was whilst he was in custody, he was serving his term, that he used to write letters to the president, the head of state at the time, Flight Lieutenant General Rawlings. I think he used to write every 2 weeks. He writes letters asking to be given, parole, like to be the mercy, pardon should be extended to him. Then the president asked that an investigation should be carried out because he didn't have the facts. It was after the facts were made known to him that for his execution. Would that change your mind if a case like that is posed to you? I mean, the facts are so vivid. Thank you very much, Mr. Chairman.
Mr. Chair, thank you very much. That the facts that you have given will change my mind. Is that a question, sir?
Yes, that if you had a situation like that, when the person gruesomely commits a murder, premeditated, confesses to his uncle, and then later he writes for a reprieve, will that change your mind?
No, that will not change my mind. That is what I said. We should have degrees of murder. And if he deserves to be hanged, then that is it.
Thank you very much. Oh, you want to follow up? Oh, very well, very well. Yes. Mr. Chairman, I read from page 5 of your CV. And by the way, after your nomination, I made inquiries from some of my colleagues at the bar. I haven't had the privilege of appearing before you, but they have very kind words to say about you, your body language, your temperament, and your readiness to teach, has been manifest, and I've gotten that feedback from a number of lawyers. So I think you can proceed along that line. But on page 5, hobbies, reading and current affairs. Now, Russia, Ukraine. Now, this matter is a very live issue. What is your sense of where this war is going? But we are doing current affairs.
Sorry, Mr. Chairman, thank you very much. this Russian-Ukraine situation is some kind of albatross around the neck of we, the developing countries, actually. It's unfortunate when the big boys are messing up around themselves, then we are suffering. With all due respect, I think Russia's invasion of Ukraine, I personally am not happy about it. That is all I have to say.
My Lord, do you have all the facts?
No, I don't have the facts. That is what I said.
You know, as a judge,
thank you.
You don't pass a judgment until you have all the facts.
No, that is what I said. Personally, I don't feel comfortable. So, thank you.
You see, Mr. Chairman, this matter is not likely to come before our Supreme Court, so he has every liberty to. Russia-Ukraine war.
It's all right.
All right.
There may be a Russian and a Ukrainian businessman living in Ghana, and they may litigate in any of our courts.
Very well, Mr. Chairman. My Lord, you have been nominated for appointment to the Supreme Court. Now, the history shows that not many people got this kind of privilege that you have had. Now, it's also has to be put on record that one of the people that got that kind of privilege, and I'm here referring to Justice J.N.K. Taylor, you know, someone who left indelible mark in the science of history. Now, you are going to the Supreme Court. What do you want to be remembered for long after you have left the Supreme Court? Thank you, Mr. Chairman.
Thank you, Mr. Chairman. I want to be remembered for deepening the values and the principles enshrined in, especially the preamble of the Constitution. All those we have there. Let me, with your permission, Mr. Chairman, if I may just read the preamble: spirit of friendship, freedom, justice, probity, and accountability, the principle that all powers of government spring from the sovereign will of the people, the principle of universal sovereignty, the rule of law, emphasis on rule of law, protection and preservation of fundamental human rights and freedoms, unity, which is already been done. I want to be part of that in order to help deepen the values and the principles of the Constitution.
My Lord, I wish you well. I take note of the Volta Bar president sitting right behind you.
Yes, Eric.
Thank you very much, Mr. Chairman. Mr. Chairman, I've just been given a copy of the resignation letter tendered by the nominee. And reading through, I'm interested in the last paragraph. And with your indulgence, I would like to read. I wish to thank the party for the opportunity given me to serve at all the levels of the party. Mr. Speaker, if you serve at all the levels, then we are talking about the branch, the constituency, the regional, and then the national levels. But when you look at the CV, the nominee is talking about having served in the capacity of a constituency chairman and as a parliamentary candidate. Is he hiding something from us?
Look at the levels.
Because when you look at the letter, he has served at all the levels of the party. But the CV does not support that. I just want to find out from the nominee if he's hiding something from this committee.
Yes, are you hiding something?
Mr. Chairman, there's absolutely nothing that I'm hiding.
So
I'm not hiding anything at all.
The levels you are referring to is levels
yes,
for constituency.
Constituency.
Yes.
Just a follow-up question. My Lord nominee, just want your attention. Yeah. You read earlier on the provisions regarding the eligibility to be nominated to be a Supreme Court judge does any of those provisions state that if you're a Supreme Court judge, you cannot belong to a political party?
Mr. Chairman, I don't think I understand the question clearly. If the honourable member may come again.
Yeah, you indicated earlier on the eligibility criteria, the number of years you should be a member of bar and all that. You read that earlier on. And I'm saying that when you look at the Constitution, is there any provision there that prohibits a Supreme Court judge from being a member of a political party?
Thank you, Mr. Chairman. I haven't come across any, and I don't think there's any in the provision that I read to the committee.
So why are you running away from your membership of the NPP?
Mr. Chairman, it's only fair. And when you look at the judiciary, the way it is created, you are supposed to be a neutral arbiter. There's no way you can belong to any political party.
The reason why I'm doing this follow-up question with you is yesterday, another nominee sitting there, I asked similar questions about the fact that Supreme Court judges pretend that there's nothing political about the work that they do, when we all know that your mandate to interpret and enforce the Constitution and to manage the relationships between the coordinate branches of government, the legislature, the judiciary, and the executive, and to manage the relationship between the central government and the local governments. Those entail political choices. And your politics will definitely impact on which way you go. So I'm saying that why do we run away from the obvious, that we are also politicians sitting there as Supreme Court judges?
Mr. Chairman, thank you very much. If I understand the Honorable Mohammed Ayariga clearly,
No, he knows me very well. When I was in law school, I used to be called Mohammed.
Thank you. Well, in all seriousness, the Constitution itself is a political document. But what judges are not, well, in every choice, in every decision you make, there's some amount of policy. It can be private or whatever. But what I think we cannot do as a judge is to be partisan. That's the way I understand it. Thank you.
Thank you very much, Mr. Chairman. Going through the CV of the nominee, I read the nominee has served in the capacity of the chairman of the New Patriotic Party for the whole West constituency. Can you share with us your key achievements serving as the chairman of the New Patriotic Party?
Mr. Chairman, thank you very much. But it's a long time ago. I seem to have forgotten some of the things we do. But we kept, for those moments, we kept the party alive in the constituency.
Yes, are you done? Yes, please.
Mr. Chairman, I asked a question. No, please, this is my first question. Please, the first one, I was also looking at the document that was submitted.
It is still a question, but proceed, please.
Mr. Chairman, yeah, you were not following. I asked a simple question. And I wanted to premise the other questions on the answers that the nominee will provide. I ask that from the CV, the nominee has indicated to us the various capacities in which he has served. And I'm interested in his capacity as the chairman of the New Patriotic Party for the whole constituency. And I wanted the nominee to share with this committee his key achievements as a chairman of the party. And I want the records to reflect. If the answer is that he kept the party alive, that is an achievement, so be it. No, I just want to confirm. Yes, he should confirm.
If he says so, it's on record. So ask another question.
No, that's not my last question. Please. Mr. Chairman, the nominee has been on the bench for just 2 years. High Court for just 2 years. He was appointed in September 2020, and in 2022, October today, he's before this committee, heading towards the Supreme Court, heading towards the highest court of the land. Can the nominee convince this committee that he has the required experience to assume the office, the high office of a justice of the Supreme Court of the land?
Thank you very much, Mr. Chairman. I can assure the honourable member that I have the required and the requisite experience to sit in the Supreme Court as a justice of the Supreme Court. What is the qualification? 15 years at the bar. I'm 22 years, and I'm not the first person to have ever been appointed. There are people who are appointed straight from the bar without any judicial experience or bench experience. I have been on the bench. I have the experience already, and I think that I have the necessary experience to sit there. Thank you very much.
Last question. My last question, Mr. Chairman. Honorable nominee, you know judicial independence is critical to fairness in justice delivery all over the world. What do you think must be done to insulate the judiciary of Ghana from political influence?
Thank you, Mr. Chairman. Article 1, 2, excuse me, before let me just refer. I think in Article, let me just paraphrase it. The Constitution provides for the independence of the judiciary. Yes, independence of the judiciary. And there are three types of independence. We have the judicial independence, administrative independence, and financial. I can speak to the fact that for judicial independence and administrative independence, the judiciary is quite independent. I cannot speak of that of the financial independence because I hear from the corridors of power, the corridors of the judiciary, that when budgets are handed over to honorable members for consideration, it is slashed. So I don't believe there is a financial independence there because of the budget cut.
Sorry, Chan, did you say when monies are handed over?
When budget.
Thank you.
No. Yes, Honorable Gaewu.
Thank you very much, Mr. Chairman. Yes, my good friend. Congratulations.
Thank you, Mr. Chair.
Yes, in your practice and at the bench, I'm sure you would have come across cases, or you would have been involved in cases where eventually the maxim that ignorance of the law is no excuse has been raised. That it is presumed that the law is public knowledge, and if you're ignorant of it, it doesn't absolve you from any charge. Now, given our circumstances, do you think that even though cases are handled on their own merits, do you think that in every case, ignorance of the law should be no excuse?
Mr. Chairman, thank you very much. Well, I think that yes, the law is that the ignorance of the law is no excuse, but when it comes to sentencing, you have to look at it such that you may prefer the minimum sentence, or even caution and discharge, or sentence the person to 1 day or whatever. Thank you.
Well, I will draw your attention to our circumstances here, where sometimes access to legislation passed by Parliament is even difficult for the Supreme Court. In the case of the Honorable Mark, in your case against EC on the CI, what's the name of the plaintiff, your client?
Amen,
sir. Amen, sir, against the Electoral Commission. The Supreme Court said, after the defense by the EC, that they relied on CI 78 to declare the district assembly elections open. The Supreme Court said that legislation did not exist and that it was phantom law, simply because the Supreme Court did not have access to CI 78. Now, as a follow-up to what I just brought up, what do you think should be done for the average person to have access to legislation so that this maxim will be effectively applied?
Thank you, Mr. Chairman. Then that will come to Council for Civic Education. It is their mandate to bring to the knowledge of the people, and by that the laws of the country, and to sensitize them of the changes in the law. That's the way I operate.
Let me do a little follow-up on this maxim. This maxim, or saying that ignorance of the law is no excuse, is in fact one of the inherited other principles or maxims from a jurisdiction that is alien to us. In Ghana, the laws are made by Parliament, published in a language that is spoken by just a small percentage of the population. And in our everyday movements up and down, the people do not speak English. So, is it fair to continue to apply this maxim that ignorance of the law is no excuse, when even lawyers, sometimes even judges, don't have access to new laws that are made, and Parliament makes new laws every day?
Thank you, Mr. Chairman. I think the maximum should continue to exist because there are people who may deliberately know that what they are doing is wrong, but they will persist.
Yes, I will please continue.
Yes, I would ask one general question and end it. You are going to the Supreme Court. You are before us. It's more or less your interview for a job. What is the work of a Supreme Court judge?
Mr. Chairman, thank you very much. And that will take me to what the Constitution says is the work of the Supreme Court, and that has to do with the jurisdiction that is conferred on the Supreme Court, what to do and what not to do. The Supreme Court is a creature of the Constitution, and it has a very extensive jurisdiction. Have the original jurisdiction first for interpreting the Constitution itself. That's one jurisdiction. The next one is for the enforcement of the jurisdiction. Then, the enforcement of the Constitution. I'm very sorry. Enforcement of the Constitution. Then, if any act of Parliament or any other law is found to be inconsistent with the provisions of the Constitution, and it is brought to the attention of the Supreme Court, will rule on it and strike down that act of Parliament. Then we have the appellate jurisdiction of appeals from the Court of Appeal. They are in twofold: the criminal appeal and then the civil appeals, which are of rights by the individuals. We have other jurisdiction as the supervisory jurisdiction of the Supreme Court. Then we have the referral jurisdiction. We have the election petition jurisdiction. What else have I forgotten? Did I mention the appellate jurisdiction? I think I mentioned the appellate jurisdiction. And then we have the production of official document in order to protect the state from disclosing serious matters that may compromise the security of the state. And then there's another jurisdiction, I think Article 14(7), where if a person who has been tried, sentenced, has finished serving the sentences, come out later to appeal that he did not commit the offense, it is a Supreme Court jurisdiction to determine the amount of compensation to be paid to that person. There are other jurisdictions, very, very extensive and wide. Thank you, Mr. Chairman.
Very well. Yes, I'll give you one.
My Lord, congratulations.
Thank you.
Let me refer you to your own CV, page 5. Item number 4.
Here you state that you attended a sensitization workshop
on national security strategy for judges of the superior and junior courts on the 28th March 2022. Now, can you tell this committee how the national security strategy clearly relates to the judiciary and the work you'd be doing if you make it to the Supreme Court? There is a nexus, and that is why, you attended a sensitization workshop. So what were some of the theses that you would like to share?
Well, thank you very much, Mr. Chairman. Well, it is acknowledged, and I believe you acknowledge, the national security has come out of a new security architecture for the country. And when you take the judiciary as the third arm of government, they are a major
arm of the government and major players. We do a lot of things that we have to protect the unity of the country. Cases that have come before us, the way we handle them can actually create disaffection for the country, or what they can create security confusion, and we are sensitized on some of these things and some of the flashpoints. We have to look at things we have to look at, and then in order to continue to hold the unity of the country together.
Did you discuss judicial corruption or corruption in the judiciary as a threat to the peace and security of our country?
Oh, yes, we did. It was discussed that when the perception continued to be that the judiciary is corrupt, it's a recipe for security threat.
Would you want to proffer any solutions to dealing with that perception?
Mr. Chairman, thank you. I think I've answered this already, where I said judiciary as an institution, there are major players. There are individuals, there are the hard-working court staffs, hard-working judges and magistrates. I mean, all the staffs, including even those who come from the assemblies as town council prosecutors, the police prosecutors, and then we have even the forensic forensic experts. They are all major players of this of the judiciary. And I know that sometimes some of the people who come to seek the services of the court may interact with somebody else who may not directly be a judge or something, and he'll carry the impression that the judiciary is corrupt. Yes, that should be of concern to all of us anyway. And I think that the mechanism I've said already have already been put for that of judges and the court staff, where we have a code of conduct and then administrative mechanism put in place to see to the compliance of this code of ethics, and then we have the impeachment procedure in order for errant judges.
Last question. You alluded to the eligibility criteria for the appointment of Supreme Court judges, and in your estimation, you qualify, and then you further demonstrated how qualified you are by making reference to the fact of having served on the bench for a period of time. Now, the question I'd like to ask is whether you are aware that when a person is nominated for appointment as a Supreme Court judge from the bar, one ought to draw a distinction, because in the case of a servant like your good self, having served in the High Court, this nomination must be seen as a promotion, and for which reason, if you have to be promoted, you must have demonstrated some sterling qualities to warrant the promotion, distinct from being nominated straight from the bar. Would you want to share with us some of the sterling performances you have exhibited over the period that you served as a justice of the High Court to warrant this promotion?
Thank you, Mr. Chairman. May I correct the impression? In the first place, it is the Constitution which says I am qualified. It's not me. For sterling performance of the bench, it's for my supervisors to tell. Well, I have been doing my duty dutifully, and let me say this with all due respect. When it comes to appointment to the Supreme Court bench, it says the president on the advice of the Judicial Council, and then in consultation with the the Council of State before this house. Well, my personal feeling is that when there is a vacancy for appointment, it is the Chief Justice who is the Chief Administrator who will bring this to the attention of the Judicial Council, for which the President will be advised. And if the President is advised, then the process kicks in. And when you are selected, that is it. Sorry about that. So I think this is my answer.
Yes, I'll give you one question before I close.
My Lord, the question was asked. Your answer seems to be saying that it's up to the President to decide who should be nominated. But it is also up to Parliament to agree with the President and approve the nomination. So if this committee or any member of this committee wants you to satisfy them also that yes, the President has nominated you, and one of the documents we have here is that you were the President's party member, and we also have documents that show that you contested as a candidate on his party's ticket, and we also have documents that show your picture by him on political billboards. So we here are concerned about whether the nomination was simply because you share the same billboard with him, or that you really are a good material for the Supreme Court of Ghana. So answer that question, and don't tell us that it's for the President to decide, because it's also for us to decide.
Thank you so much, Mr. Chairman. What I think the honourable member got my answers wrong. But let me say that for what he asked about was sterling performance, I don't think I will sit here and be able to determine what exactly I did on my sitting on the bench. Maybe it could be from my judgments, my rulings, and my work ethics that may work for me. I may not be able to tell.
As I was saying, thank you, Chairman. Congratulations to you on your nomination. Honorable nominee, you were appointed to the High Court in 2020. Did you, within that period, comply fully with the asset declaration law?
Mr. Chairman, thank you very much. Mr. Chairman, I did.
When were you supposed to declare your assets, and when did you declare your assets?
Mr. Chairman, permit me to pick the document and be able to speak to it properly.
Are you done?
I did declare the assets on the 22nd day of June 2022. When we came onto the bench, let me be honest with the committee. The forms were given to us to fill, and I took it to home. I filled them only to forget and let it know until I later on got to realize that no. Then I went to comply. So.
You eventually complied.
I did.
That's
did.
What
Yes.
you want.
Yeah,
You eventually complied.
Yes, I did.
Can you give the date when you
22nd June.
22nd June
2022.
Yes, but you have filed it.
I filed it, and I have the certificate. I have the
No. What I'm saying is that you filed
the receipt.
That's okay.
Mr. Chairman, I just want it properly on record that
he was appointed in 2020, September 2020, and he filed 22nd June 2022, according to his testimony. And I'm sure he knows when he should have filed. But I'll move on to my next question. Corruption, you say, is a threat to justice delivery. Between, and let me quote Cassandra Buck, who says that, quote, judicial legitimacy rests on the perception of judicial impartiality, unquote. Between corruption and judicial impartiality, which is most threatening, in your view, especially within our context, to the justice delivery system in Ghana?
Mr. Chairman, corruption. sorry about that. I'm not too familiar with it, sorry. So corruption.
Corruption, in your view, is more of a threat than judicial impartiality.
Well, judicial impartiality to some extent. Okay, let me put it both. Yes, both.
Well, Mr. Chairman, I hope you don't count this as my substantive questions. I just want to establish which answer he is giving this committee.
Mr. Chairman, both are a threat to the security of the nation.
Thank you. So, both are a threat to the security of this country. Now, yes, in answer to questions earlier, you point to the fact that there is really no constitutional bar on any judge to belong to any political party. And perhaps that justifies your affiliation with the New Patriotic Party and the work that you did, and you have decided to resign as a result of this nomination. But if you consider judicial impartiality, yes, if you consider, he said so, please. No. Yes, it's here, the High Court. Yes, or because of this. Okay, so if you agree with me that judicial impartiality is also a threat to the security of this country, based on your background, how will you suggest for us as a people to guard against the, perception of it, based on your experience in our judicial system? How should we? I mean, other jurisdictions, they use jury trials, they use recusals, appellate reviews. In our context, and with your experience, if you are on the bench, how do you think as a country we should guard against the perception of judicial impartiality, which you agree is a threat to our security?
Thank you, Mr. Chairman. Well, a judge sitting on any case is by principle, and let me say that for a judge or a judiciary, a judge sitting on any case is the most transparent work you can find in this country. When a writ is filed, it is public. When the cases are being heard, anybody at all can apply for the proceedings. And when you even write your judgment, it's there, it's for the proceedings, for people to see whether you have bent the rules or you have done it in accordance with the principles and the law. It is there to expose you, and that is enough against you to be impartial. And to the extent that even academia can take your judgment, analyze it, and you'll be exposed. So these are the elements that guard against you to become so impartial and in determining a case. Thank you, Mr.
Now, your case is peculiar Yes, you have made the point that you are not the first to be appointed, given the number of years you have been at the High Court to the Supreme Court. Some have even gone there without any experience. But I was a bit disturbed that you didn't seem to come forth well with your trump card on the bench, for which reason you think you are catapulted to, the Supreme Court, especially so when you were asked about your achievement as, the chairman of the New Patriotic Party. Your answer was just that you kept the party alive. It makes me wonder your level of competence and your drive for achievement, because this committee is to assess that, and we will look at your past record. So as chairman, you only kept the party in a 20. That's your trump card. Well, the party is still alive. The party was alive before you came. But it's not really something that tells me about your competence and your ability to deliver. Then again, on the bench, I want something that I can say you delivered. For which reason you were nominated for this, and not just because you are associated with the president's party.
Thank you, Mr.
Is that a question or your comment? If it's a question, I want to, but it appears to me to be running a commentary. So can you ask the question so that they will answer you?
Okay, so the question is about your competence in these two roles that you have held as New Patriotic Party chairman in Ho, is it Central, or in fact both, Ho West and Ho Central, your competence, and then also on the bench, your competence.
Well, Mr. Chairman, before I came this afternoon, thank you very much, Mr. Chairman. Before I came this morning, I tried to find out the number of cases I've finished or the rulings and judgment I've written so far from when I joined the bench up to before I came here. What my class gave me is about 70 rulings and judgments between the period. Well, I'm sure that satisfies the question.
Are you certain or what your clerks gave you?
Yes, I'm not too certain because but they mention it. They mention it like it's about 70. I can still provide the.
Well, this may be controversial, so very well. You will come.
And I'm saying judgments and rulings.
Judgments, rulings, and right together. Very well. All right, we will come. We will come there. That's right. The clerk said, but if it's necessary, we'll wait and get all that information to verify. But, Honorable, my lord, there's this issue about being a chairman, keeping a party alive is not an achievement. If you're a chairman of a party in a constituency which is overwhelmingly the other side and actually hostile to the party you belong, you think that is not an achievement? Would you say that is not an achievement to keep that party alive? Yes, a follow-up question.
Mr. Chairman, are you asking a question, sir?
Yes, I was asking if, in your view, keeping a party which is overwhelmingly, you're overwhelmed by the other side, which is actually also very hostile in that environment, keeping that party alive, would you say that is an achievement or not?
It is an achievement, my lord, Mr. Chairman.
Thank you very much, Mr. Chairman. My lord, congratulations on your nomination. As a follow-up to
the question earlier asked by my colleague, I noticed that you, in your response, said that this morning, prior to you coming, you are trying to put together a number of cases that you are actually sat on. May I propose, Mr. Chairman, that this is the House of Records, and in order for us to get accurate, or rather have accuracy to responses, can we grant my Lord the opportunity to go and put together the number of cases so that we are able to. No, he wasn't certain, and you can't. This is a House of Records. He said something about. So,
don't worry. We are not done. If it becomes necessary, we may ask him.
So maybe he can withdraw the number. Yeah.
Yes, Honorable Chief.
Thank you, Mr. Chairman. Mr. Chairman, I just want to do a follow-up to the question that you asked, and I was wondering whether you insisted that keeping the party in a region that is hostile is an achievement, and the nominee agreed with you. Did you agree with Mr. Chairman? You agree with Mr. Chairman that keeping a party in a region that is very hostile.
There was no use of the word hostile.
No, I'm saying the chairman used the word.
Well, I didn't hear that.
Yeah, he said very hostile to the party you belong to. And you agree with chairman. You say yes, it's an achievement.
No, what I said was that keeping the party in an environment where your main competitor is, the dominant party, about 95%, it's an achievement. That's what I said. But I didn't use the word hostile.
All I just wanted to be sure whether you did agree with the chairman that was an achievement.
I didn't use the word hostile. It was when you supplied the word hostile.
Don't worry, I use the word hostile. You don't agree with the hostile, it's okay. But it is a major achievement to keep the party alive. So the chairman is just saying that it's an achievement, and you also agree that it's an achievement. Do you agree it's an achievement?
That's the chairman's opinion, sir.
Oh no,
yes.
I'm only asking
and for me, coming from that area, it is an achievement for me.
Oh, okay. So that means an achievement, and this is the reward you are getting for that achievement.
Mr. Chairman, I'm sorry, no. No, if it is, no.
Okay. Mr. Chairman, I just want to find out, if you're looking at my law's CV, he's had the opportunity to serve on the board of the whole teaching hospital from 2020 to date. Is that right? Your CV says so?
Yes, that is so.
Very interesting. I've been around this table or in this committee for over a decade and a half, and you are the first judge or somebody who has appeared before us from the bench that also serves on agency board. I believe it's very instructive to all of us. On your CV too, it also says that you were the government appointee on whole municipal assembly between 2002 and 2004. Is that right?
That is right, sir.
Mr. Chairman, I just want to take the nominee. In his earlier answers to questions, he was of the view that the constitutional provisions were just for you to have 15 years at the bar, and once you have proven integrity, you are qualified to be at the Supreme Court. Did I hear you say that?
That is what the Constitution says, that 15 years at the bar, proven integrity and high moral character.
And you also said that you know others who have just moved from private practice without even a bench experience and to the Supreme Court straight. Is that right? I heard you say that too.
That is all, Mr. Chairman.
And did I also hear you say that there's an experience of somebody on the bench that was also from the High Court to Supreme Court? Did I hear you say that too?
Yes.
Do you remember who this was?
Justice J.N.K. Taylor, Justice V.R.C. Crabb.
Well, so when you look at Justice John Nicholas Kobna Taylor, was it in this Fourth Republic?
Surprisingly, no.
Do you have any experience within this Fourth Republic that
I don't recall any immediately.
But do you know the experience of Justice Taylor before he went to the Supreme Court? I'm sure you might have read about him.
That he was a High Court judge.
You remember that he was a Crown Counsel?
Yes.
He was also a State Attorney?
Yes.
He was Director of Public Prosecution?
I think so.
He was once Acting Attorney General?
Well, I think so. I think so.
He was the Commissioner of Justice in 1969?
I don't have that fact.
Are you aware that he was on the High Court for 10 years?
That is possible. I think so.
Are you also aware that a very charitable organization that you have been a member, that's the Ghana Bar Association, did make a recommendation and requested the chairman of the PNDC to move him from the High Court to the Supreme Court?
Mr. Chairman, please say it again.
I'm saying, are you also aware that the Ghana Bar Association, of which you are a very proud member and you have served at various levels, were those who recommended and requested the chairman of PNDC, then Chairman Rawlings, to elevate Justice Taylor from High Court to Supreme Court? Are you aware of that too?
No,
okay.
I'm not.
So let me bring you back home. What is the progressional trajectory on the bench?
Well, I don't have that before me, and I don't know what the project, but what I know Constitution says is that when you have 10 years as a lawyer, you qualify to be a High Court judge. And when you are a lawyer of 12 years standing, you qualify for the Court of Appeal. And when you are a lawyer of 15 years standing, you qualify to the Supreme Court bench. That is what the Constitution is saying. But the Constitution does not give the promotion trajectory that I know.
In Parliament, we work with the 1992 Constitution, our standard orders, and then our practice. And you know the practice, every magistrate judge aspires to be a circuit court judge. Is that right?
Well, when you are a magistrate of 3 years standing, when you are a lawyer of 3 years standing, you qualify to be appointed a magistrate. And when you attain 5 years as a lawyer, you qualify to be a circuit court judge.
Yeah, I'm just talking about the trajectory. I'm just saying that anybody who starts as a magistrate judge aspires to be a circuit judge. Am I right?
You are right.
And you have a circuit judge aspiring to be a High Court judge.
Yes, you are right.
And a High Court judge like you yourself who aspire to get to the appeals and the Supreme Court. Is that right?
You're right, sir. Sorry, Mr. Chairman. sorry.
Okay. Do you believe that these judges, as they move from magistrate to circuit to high to appeals and Supreme Court, you believe that they also see this as promotion? Is that right?
That the judges see it as
promotion. They move, as they get the opportunity to move from magistrate to circuit to high court, appeals court, and Supreme Court, they see it as promotions.
That is so.
So if your CV says that you joined the bench in September 2020, and in July 2022, you are going to be moved from the High Court, skipping the Appeals Court, to Supreme Court. If it is not you, and it's another High Court judge that you see that happen whilst you are at High Court, naturally, how are you going to feel?
Oh, well, by nature, I'll feel proud for the person.
And you'll be happy as a High Court judge, see a colleague comes to join the bench, and in less than 2 years, he or she moves to the Supreme Court, and you'll be very proud and congratulate that person, and you'll be happy in yourself.
I'll be very happy for that person.
Earlier when you mentioned, even though I realized that the chair and my colleague, Honorable Henry Kwete, were trying to give a caveat, I'm not sure you want to cross-check and be certain about the number of judgments that you have delivered. I know that every year you are supposed to file the number of cases that have come before you and the rulings that you have made, right?
Yeah, that is so.
And it is charged based on 3 categories. 1, reasoned judgment. Right? Right?
Sorry, that is so.
And the reasoned judgment, can you help us? Because many of us are not lawyers. What does that mean? The reasoned judgment. What does that mean?
A judgment includes a ruling and orders. So when application comes before you, application comes before you, you determine it on what the people or the parties are asking for. You give a reason why you prefer one argument to the other. And the other is that when you take evidence, a trial, you go to trial. And at the end of the trial, you write your judgment based on the facts, the piece of evidence laid before you, and then you come to a reasoned determination why one person will have to carry the day.
So for me as a layman who is not a lawyer, it simply means that when a case comes before you and it's determined at the end of the day and you've given your ruling, that's what is called the reasoned judgment. Am I right?
Yes, you are right, including applications that come before you, like interlocutory applications that are contentious.
Well, you are now confusing me because I'm a layman. You also have reasoned ruling as part of the category. Am I right?
Yes.
And what is the reasoned ruling?
The reasoned ruling is a ruling because there's an application before you where there are 2 contending ideas or reason why you have to prefer one, and then you have to take them one by one, run them by the facts, the evidence they are presented before you, and the law. Then you come to a reasoned determination.
Now, you see, when you were explaining the reasoned judgment, you made us to believe that when a case comes before you and you make a determination, after evidence has been taken, as you said. But I heard you were also talking about interlocutory injunctions and other things. But I thought that was the reasoned rulings.
It is a reasoned ruling because facts presented before you.
Don't
There's
worry,
evidence.
my lord. I just want us to be systematic.
Thank you.
And I realized in the first instance you were mixing some of the reasoned ruling as part of the reasoned judgment. Because I'm trying to deduce that 3 levels are used as basis of judging the work that you've done over a year. And we've gotten the reasoned judgment. We are now at the reasoned ruling. And then where you have consent ADRs, where you are able to get them to agree among themselves using alternative dispute resolution method, isn't it? So these are the 3 levels upon which you are judged. So the depth of work in actual is in the reasoned judgment. Do you agree with me? Because you are a judge. So that's where the real depth of work is.
Yes. Even some applications are also seriously contentious, like application for mandamus, certiorari. interlocutory injunction and all these matters, they are also where, except that you don't take formal viva voce evidence, but the evidence and the facts are presented on paper on which you have to read and determine one way or the other.
But you agree with me that the reasoned judgments are the ones that are the bulk of the work in your court?
The bulk of the work, sorry, finish that.
Yeah, that's the bulk of the work, and that's when you have made determination of cases, and now they no longer need to come back to you unless maybe they're appealing elsewhere, isn't it?
Mr. Chairman, I disagree, because some of the applications are quite contentious and it brings the matter to finality.
I have in my hand the statistical tabulation of submitted judgments of judges of the High Court, Circuit, and the District Magistrate Court, commencing October 2021 to September 2022. And I found it very interesting reading, because interestingly, over this period, you've had only 7 reasoned judgments. 7 reasoned judgments. And I can have an example of other justices of the High Court. Someone like Charles Jemfi Dankwa did 31. You have someone like Justice Kofi Dogu did 21. You have someone like Justice Hafsata Amale Boba did 88. You have someone like Justice Mrs. Cecilia Yila Don Chiba, John Chibi, Agbevile, 34, and the list can go on and on and on. And you think that when these justices hear that you have done 7 in a whole year, it's been elevated to Supreme Court, and you want them to be very proud and congratulate you and be happy.
Mr. Chairman, let me ask you, is it for which period and which specific cases?
I said, these are, I read the title, the statistical, maybe I have to give you a copy of what I'm holding. It's the statistical tabulation of submitted judgments of judges of the High Court, Circuit, and the District Magistrate Court, commencing October 2021 to September 2022. Greater Accra region.
Thank you, Mr. Chairman. Let me get the reason is that this, and between the period December to February, I was on leave, and I resumed on I think the early March, then to do these trials. These are trials. With the trials, you take. There are reasons why maybe the cases were not moving, but these were the cases we were able to determine, and the application, there should have been the applications as well. That would have solved the problem.
Mr. Chairman, I'm making reference to it now. I'll give it to you. Now, you said you were on leave within which period? You said you were on leave within which period? Come again. You said you were on leave
between December and February. I think so.
Well, I thought that all the justices also go on leave at different periods.
I was a vacation judge last year.
And you want to tell me you were the only vacation judge in the High Court?
No, I was not the only vacation judge, but I was in the vacation judge where I was assigned 5 courts to hold for the vacation.
So my expectation maybe would have been that you would have had more cases.
Yes.
You will have many more cases would have come to you.
Yes, but the vacation, it's only with the consent of the. Some cases from other courts are brought before you, but you cannot go into the substantive case. You only deal with the applications and the applications. Essentially, that's what you deal with, but don't go into the substantive cases unless the parties agree with your own case before you.
Are you aware
that there's a High Court that have been at the High Court for 17 years?
I don't know, but that may be possible.
Are you aware there's an appeals court judge who have been an appeals court judge for 15 years?
No, I don't know. That is possible.
But you know that it's a matter of fact that every appeals court judge prayer is one day to arrive at the Supreme Court.
Well, that may be possible.
Do you know Justice well, okay, but the chairman said I should leave names out. What I would just want to say is that maybe let me just take you to the asset declaration. In an earlier answer to a question, you said that you declared your asset on 22nd June 2022.
Yes, sir.
Your elevation to the High Court bench was in September 2020.
Yes.
And you said when you went to the bench, you completed your asset declaration form but forgot about it.
Yes, sir.
Are you aware of the 1992 Constitution Article 286 and its provisions?
Let me please refer 286. Yes, I've seen it, sir.
Mr. Chairman, with your permission to assist by law, let me read. Who holds a public office mentioned in clause 5 of this article shall submit to the Auditor General a written declaration of all property or assets owned by or liability owned by him, whether directly or indirectly. A, within 3 months after the coming into force of this Constitution or before taking office, as the case may be. B, at the end of every 4 years. And C, at the end of his term of office. I know that as a member of the bench, especially the Superior Court, you work daily with the Constitution. And how could you forget such a fundamental requirement of the Constitution as a High Court judge?
Well, Mr. Chairman, it's possible because the work of a judge is such that when you rise from your house straight to the courtroom, your whole attention is on court and attending to your matters. You get home, you have to go write your rulings and come back the following. And it just got lost on me. Just got lost on me. And that is why I quickly did it. When the Chief Justice prompted us and reminded us that those who haven't done it should do it.
Did you watch the vetting of the Supreme Court justices in May 2020 in Parliament?
No, please.
You were not also following
May 2020?
In May 2020?
No.
And you were not also following what was also happening?
What was happening like?
What? I mean, after, if you don't watch the vetting, like from the vetting, the media reports what has happened, and there's publication in the dailies and all that. There are people try to repeat all the questions on social media. You didn't follow through any of this?
No, I didn't.
Because my worry is that if, with all respect, my Lord, if you are a practicing lawyer and judges are going before Supreme Court, the parliamentary committee, and all manner of questions are being asked, I thought as a lawyer you should be interested in following, because consistently we were asking about this as a declaration and what have you, and all this didn't remind you about
you haven't completed your, what do you call it, asset declaration. We vetted ministers in 2021. You saw almost the 80-something of them. Almost everybody was asked about asset declaration. I mean, the Auditor General was talking a number of times on radio about asset declaration. All that didn't dawn on you to get to do the right thing until almost, 1.5 years after the time for the submission of the asset declaration. Will it be fair if someone says that you were negligent, for lack of just a more word?
Mr. Chairman, negligent is too strong. I only, like I've explained the reason. It was the forms were given. In actual fact, when we were brought to the bench, straight away we're given cause to handle. And when we came, there were so many cases. In actual fact, when I took over, there were about 600 cases. And then it got lost on me. I'm sorry about that. I apologize even to the Chief Justice of that.
Well, let me just move on. Have you been subject of any judicial misconduct?
No, please.
Now, you know the bench that we have at the Supreme Court, since this Fourth Republic, had not gone beyond 14 until 2020, when the current president moved it above the 14. Now, with the economic challenges that is confronting us and all that, in your view, how many people do you think we best to have at the bench of the Supreme Court?
I have not affected my mind to that, but I hear the debate. And Mr. Chairman, if you permit me, let me read the article. It says the composition of the Supreme Court should be the Chief Justice and 9 other justices at least. And my Lord, sorry, Mr. Chairman, if you read Article 93 itself, Article 93, there's another compelling argument there that there shall be a Parliament of Ghana which shall consist of no less than 140 elected members. Mr. Chairman, this debate is also there. Now we have over 275, which is over double. 275, sorry, which has over double the 40. There is a compelling argument there also that yes, when we take the economic argument, the economic argument may not necessarily hold, Mr. Chairman, because at the time this constitution was enacted, the courts in existence are not necessarily the courts that are still there. Due to population expansion, courts have been established. This year alone, several courts have been built and some are ready to be open for use. So you see that, and with the extensive jurisdiction conferred on the Supreme Court, we cannot see that the numbers should be limited. Let's leave it flexible, just like Parliament. When we thought that we have 275 now, and we may be going even beyond that because of governance. I think that the economic argument may not necessarily be the reason to curtail. And I remember when I was in practice, we had only one Court of Appeal. We all traveled from Bolgatanga, wherever, to the Court of Appeal in Accra. But now the Court of Appeal, because of Court of Appeal have been opened in other regions, in the regional capitals. So this is what I would say, that the economic argument itself may not be appropriate.
Mr. Chairman, it looks like everybody wants me to stop, so I'll thank you for the opportunity to have asked the question.
Chief Whip, the Chief Whip has no question. Very well. Honorable Deputy Leader, right? Let me use the washroom.
Yeah, sure.
Quickly. Using the washroom quickly.
My Lord, I have
Chairman,
looked at CV, and you state that you were born in Ho, in the Volta region.
Yes, Mr. Chairman.
And you come from
Abutia.
Abutia in the Volta region. Yes. Where is Abutia?
Abutia, it's when you're traveling from Accra to, you get to Sokodi. You branch off from Sokodi, Bogamen, and you go to Abutia. It's a very nice and beautiful area.
In the Volta region?
Yeah, Volta region.
So you come from the Volta region?
I'm a Voltarian, pure and pure.
Both parents?
Both parents.
So you speak Ewe?
Very, very well.
Fluently?
Fluently.
What is the meaning of Amegache?
Amegan is a name, but we can take Amegan to mean a big man or a boss.
Right.
And then the chair is the, what do you call it? The chair is the younger one.
Okay.
Yes, the chair is the younger one. So when you say Amegan, then so Amegan, then Amegan chair is the younger one of Amegan.
Okay, so Amegache is a Volta name.
It's a Volta.
It's just as if you say marking.
No, it's an ever name. Let's put it that way.
It's an ever name. Amegache is an ever name. Very well. Okay. So now, you said current affairs is an area of interest to you. So Ghanaian current affairs, you've had interest in it, correct?
Have, sir.
Okay, so let's go.
And international affairs.
No, I'm interested in local current affairs. My lord.
Yes, Mr. Chairman.
I claim your attention while I proceed with my necessary questions.
Thank you very much, sir.
2001 to 2008, we had President Kufuor. He handed over in 2009, January 7th. January 7th, Professor Mills of blessed memory took over. Now, within the period, if my memory serves me right, we first had my Lord Pega when Kufuor assumed office from the Volta region, correct?
That is correct.
Correct. And then when Kufuor came, within the 8 years, my Lord Professor Kluje came in, correct?
That is correct.
It's from Volta region?
In the same town as Pega.
From Volta region.
That is so, sir.
From the same town as Pega.
That is so.
Right. Then I am presiding. Yes, I'm the vice chair. And during the temporary absence of chairman, I take over. You want to ask me a question? Eric, stop. You and I share the same esprit de corps at our level. And you know you are not entitled to do this to me. Now, my Lord JVM Doche was also appointed. Which region is he from?
It's from the Volta region.
From the Volta region. So it means that within the era of John Ajekum Kufuor, from the records, 2 Voltarians, Evers, were appointed to the Supreme Court.
Chairman, I take objection. No, the word ever, please. And I say no. I'm raising objection, Chairman. He can raise and make reference to regions, but we will not tolerate reference to any ethnic group. Reference, especially when we're dealing with an important appointment to the Supreme Court of Ghana. With all respect, those words should be expunged from our record. People rise to that office on the basis of their competence and qualification.
The objection is to me. I've held it. It's all right. Please, reference to Volta.
Mr. Chair, with the greatest deference to my respected colleague Aaron Idrisu, he knows I know how to situate my questions correctly. The Constitution is clear that all shades.
Honorable, are you challenging my rule?
No, Mr. Chair, never.
Please proceed.
Mr. Chair, with the necessary modification.
Ask your question with.
So, part of the intimidation Intimidation Chief Mutaka Mubarak. My Lord, so my Lord JVM Doche and my Lord Professor Kluje of blessed memory were all from the Volta region.
Yes, Mr. Chairman.
Let's go on. Pay attention to my questions. Now, within the period 2009 to 2016, do you have any name from the Volta region that got appointed onto the Supreme Court bench between 2009 and 2016?
Yes, I can recall Justice N.S. Badegbe.
You can recall? Yeah. That is one name.
One name.
From
the region.
Which part, if you know?
Ho.
He's from Ho. Very well. Now, between 2017 to date, by the way, my Lord Badegbe has retired.
Yes, Mr. Badegbe has retired.
My Lord Badegbe has retired. Now, between 2017 to date, or between 2017 and now, we have had my Lord Agnes Doje, correct?
Please, the name is Agnes Doji.
Doji, thank you. From which region, please?
From the Volta region, please.
Volta, very well. And then we have had also my Lord Justice, my Lord Honyanuga. Have I pronounced it correctly?
Yes.
Honyanuga.
Clement.
Honyanuga. Which region, please?
From the Volta region, please.
From the Volta region. And is there any more apart from these two?
No, and to be honest with you, the two, Agnes Doji and Honyanuga, have been retired.
I said, is there any more that you know?
No, I don't know any.
And you recall that we had only my Lord Badegbe for 8 years between 2009 and 2016. We only had one from Volta region.
That is all.
Correct. Meanwhile, within 8 years, I mean, between 2017 and now, we have had two from Volta region.
Yes, that is all.
And if you are successful, you make it 3 from Volta region, correct?
That is correct.
Now, my Lord, you read to us the constitutional provision that qualifies a person for the Supreme Court. You had said that 10 years is the minimum qualification for a lawyer to merit an appointment to the High Court. Do you still rely on that?
Yes, I do. I still rely on it.
Is it a matter of opinion or constitutional?
It's constitutional.
Thank you.
It's the constitutional.
Thank you. 2, you again averred in response to a question that Court of Appeal is 12 years and the Supreme Court 15 years.
Yes, that is constitutional.
Correct. Is it your case that you meet this essential constitutional qualification?
Yes, Mr. Chairman, I have. And I'm 22 years as a lawyer as I sit here today.
Right. Do you have any of your mates, or do you know of any lawyer who is at the Supreme Court and is your mate?
There's no mate of mine at the Supreme Court, Mr. Chairman. Sir.
Is there anyone at the Supreme Court who has practiced less than 22 years currently?
And none that I know of immediately of my head.
or proud, do you know of any appointment to the Supreme Court that was below 22 or 22 years?
And yes, not that I recollect, but I thought, yes, there may be some.
No. Would you want to check? Would you want to? Anyway, would check some few, because I think just as we now have a very young Attorney General, we had the former Chief Justice Sophia Kufu. She got to the Supreme Court when she had not attained 22 years.
Thank you.
Yes. I state that as a fact, and the record should capture me as such. She was not 22 years at the bar, but had met the minimum constitutional qualification. So I just want to be quoted. Now, let's come back to your past life. You were the chairman of the MPP. We call you chairman. You know, that's how you feel big when you are called by that name. Not chairman, chairman. But being a chairman for whole Central,
sorry,
whole
whole
West in the Volta region is no fun, is it?
Not at all, sir.
So it requires some commitment to take up that.
A lot of commitment and sacrifice.
How would you describe your tolerance level?
You have to have a large heart in order to be a chairman of the MPP then in the Volta region. I must be very honest with you.
Right. Do you know, my Lord? Do you know, my Lord? My Lord Puaman?
Yes, I know him, sir.
What inspiration do you draw from him?
Mr. Chairman, Mr. Chairman, thank you very much. I've got to know that Mr. Justice Puaman was the General Secretary of the PNC at a point in time. Thank you.
Yes, so what I'm saying is that looking at his background, looking at what he went through when he appeared before us, what inspiration do you draw from him?
Thank you, Mr. Chairman. I have read a number of judgments delivered by Mr. Puaman. Mr. Puaman, you realize that I don't think his past experience as a General Secretary of the MPP has influenced any of his judgment. His judgments are very, very sound and good. And I will be inspired if I get a note from you, honorable members, be inspired by what
to demonstrate
yes, such
competence.
Thank you very much. Thank you.
When was do you recall when he was appointed?
Mr. Chairman, if I can recall, he was appointed in either 2013 or thereabout, or 14 thereabout. I'm not very sure.
But you recall that he was appointed by His Excellency President John Dramani Mahama?
Yes, I recall. I was a bar council member then, I recall.
Very well. And you also recall the Ghana Bar Association's opposition to that appointment that eventually led to they pursuing their issues in court. You recall?
I recall there was a case in court, but as to whether it was against his appointment, I'm not too sure.
You've done well.
I know there was a case at that point, but as to whether...
Well, so I just want to... I'm familiar with it because it was consolidated with my case. I had another matter with the Supreme Court that was consolidated. So I know the facts of that case, and just for our collective knowledge sharing. The contention of the Ghana Bar then was that the advice of the Judicial Council followed an order of merit, and that His Excellency the President at the time had no discretion to have chosen out of it from the bottom. He should have followed the order of merit by way of their recommendation. And then the Supreme Court said, no, once all of them were recommended, it's a matter of the appointer having discretion. And he didn't act contrary to the advice. He acted within the advice. Okay? So whether or not Justice Apau, who has retired, my respected, I'll call him uncle, came fourth or fifth in the order of your recommendation, doesn't matter. Once he's within, the president could choose. So I'm basically drawing your attention to the fact that somebody has walked this path of being a politician, and a prominent one for that matter. You were just a constituency chairman. He was the general secretary, and has demonstrated that he can still deliver justice right from the bar. You have an advantage of even being at the bench for 2 years. Can you assure this committee that you will deliver justice with impartiality when you get opportunity at the Supreme Court?
Thank you very much, Mr. Chairman. I can give you my firm oath that I would do that. I would deliver justice impartially.
I know what you want. So if you get a nod, how many years are you going to be on the bench?
You already have the comments. If you let, I'll bring the names out now. Thank you.
Yeah, but when your chief whip. So, my lord.
Yes, Mr. Chairman.
How familiar are you with my lord Adinira?
The retired Adinira.
That is so.
Yes, she was for most part of her life served in the Volta region as at the Attorney General office. The husband is my very good friend.
Now, my lord Atuguba, who has retired, he practiced for many years and got appointed to the Supreme Court. How does his career inspire you?
Well, thank you very much, Mr. Chairman. Justice Atuguba, I know, was appointed to the Supreme Court bench straight from the bar, and he was about 22 years as well when he joined the bench. And Justice Atuguba is one judge who has acquitted and discharged his duties as a judge on the bench beautifully. His judgments are a testimony to what he did on the bench, and it's so beautiful. I want to follow, if you give me the nod, in that line of doing my work at the Supreme Court.
So, what I'm trying to establish is that my lord Atuguba was within this 22 years of experience when he also had a nod, and straight from practice, and did so well, so respected. I appeared before him many times, and I still read his views on my cases with a lot of respect. You have had the benefits of
prior to this appointment. Again, do you assure this committee and Parliament that you follow such enviable steps?
I will, Mr. Chairman.
What inspired you to get to the bench?
Thank you, Mr. Chairman. Mr. Chairman, if you know the history of the Volta region, you realize that a number of practitioners from the Volta region had gone on to the Supreme Court bench. I can start with Justice Fred Apalu, who in the 50s practiced in Ho, Justice Waku, Justice Ajabing, Justice Ajwe, Professor Kluje, Justice Adijuna, who herself practiced as attorney from Volta region, Justice Sule Baregbe, Justice Jones Doche, Justice Doji, all this. So when you are a lawyer and you go to Ho to practice, they identify you and start to work on you. All the seniors, you are. It's like you are a child of the community. They mentor you. They tell you straight away and said, "Hey, you are going to practice for 15 years, and then make sure you join the bench and carry on the work from there." And this is what we have been doing. So you realize that
it's a career path for you.
Exactly.
To make the region proud and mentor you to make the region proud. So is that drive to make Volta region proud that got you to the High Court?
There's no way they are looking up to them. There's no way I have to disappoint them. I have to carry on.
Mr. Chairman, with all due respect, I think that the deputy majority leader's tangent is quite dangerous for the security of this country. I will advise that he doesn't make this, an issue of, regionalism, because look, the minority leader, when he went on this tangent, had to check to even see if we have ever had anybody from the northern region on the bench. Is that really necessary? Since the creation of the bench, no one from the northern. Is that the debate and the discussion we want to have? Mr. Chair, with all due respect, I think he must stay off such, references. Thank you.
If there's any specific question you're objecting to, kindly draw my attention. You're only advising that regionalism or something will become, but please proceed.
Mr. Chairman, the nominee gave us a background to what inspired him to the bench. That in Volta region, when you are a practitioner, you are mentored to make yourself proud and make the region proud, and that it is on that score that at the point in his career he decided to proceed. So what I'm saying is that coming from the Volta region, you know the weight on you from your colleagues to make the region proud. Are you committed to that?
I am totally committed to that, Mr. Chairman.
Would you be disappointed if anybody thinks otherwise?
Please don't answer that one, because question is overruled.
What have you to say to anybody who may think that you have just spent 2 years at the High Court?
Honorable, you are probably finished. If you have any other question, because what anybody says is entitled to that now. Please leave us out. Otherwise, if you have another question,
please proceed. But this one is overruled.
appreciate, Mr. Chairman. We'll continue to learn at your feet. Now, just to conclude on an important point that you raised, fundamentally, you are constitutionally qualified to be appointed to the Supreme Court, having received on merits the recommendation of the Judicial Council, which has also been validated by the Council of States according to the imperatives of the Constitution, leading to this final nomination. Correct?
That is correct, Mr. Chairman.
So, Mr. Chairman, I thank the chair for the opportunity. I thank the nominee. I congratulate you and wish you well.
Thank you, Mr. Chairman.
Honorable Ranking Member.
Thank you very much, Chairman. I will endeavor to focus on our primary task at this committee to evaluate and assess the President's nominee for the high office of Justice of the Supreme Court in accord with Article 1442 of the 1992 Constitution, noting that we are free to look at the suitability, looking at the quality and competence of the nominee within the meaning of the Constitution and the practice of it. But to note that, Chairman, that the quality of the bench reflects the quality of the law and will reflect the quality of his judgment. It's important that when we are appointing and promoting persons, I don't want to sound regional, but to know that my own northern region, we are yet to be recognized even at the level of a justice of the Supreme Court being appointed from northern region of Ghana. And Western North now being high. So probably I hope that I hope that tomorrow it doesn't become a presidential campaign, one region, one Supreme Court judge. I hope that we don't get to one region, one Supreme Court judge. But my Lord, to bring you back to a very important issue the Honorable Muntaka raised, asset declaration regime. And our collectiveness as a country to deal with economic crime and matters relating to corruption, Ghana will need to review entirely its asset declaration regime. Noting that your answers, in my view, does not satisfy fidelity to what was required of you in terms of the declaration of asset. Indeed, Chairman, I'm of the view that even in Ghana we should reverse the burden of proof when it comes to asset declaration. That's what pertains in the United Kingdom and many other jurisdictions. Unexplained wealth, in my view, should be criminalized. Do you share the view, my Lord?
Explain wealth being criminalized. Do you share the view?
Yes, there's a need for you to disclose your source of wealth. That's my view.
And then, Chairman, my second is to take you to Article 20, compulsory acquisition of land. The Honorable Suhene referred it earlier when we were dealing with the previous nominee. It states in 21, no property or any description or interest in or right over any property shall be compulsorily taken possession of or acquired by the state unless some conditions are satisfied. But my Lord, I'm interested in sub-clause 6 with emphasis, and I do so invoking your potential power and mandate to interpret this Constitution. It provides further that where the property is not used in the public interest or for the purpose for which it was acquired, the owner of the property immediately before the compulsory acquisition shall be given the first option. It didn't even say may, it says shall be
My Lord, what's your understanding of this law vis-a-vis the state selling to itself and selling to political office holders many of these lands which were acquired for public purposes, which are not being used for public purposes? They are not reverting to their original owners, and it's just for loot for the political elite. Where do you stand on this matter? Thank you, Chair.
Thank you, Mr. Chairman. But I am not aware that the land compulsorily acquired are being sold to the public. I'm not aware. But if anybody feel aggrieved and dissatisfied that the person may test the law of that particular before the Supreme Court for a determination.
Yeah, no, and even at higher court, you haven't come across it. For instance, you see in Ghana, Gifford Road site for agric mechanization, Bema Camp area there, national security area there. Then we are. What's that? Gifford Road. I'm sure the military know better where it is located.
Mr. Chairman, the honorable member knows that I've just come to Accra. I don't know Accra too well.
You know, Hope. I'll come to that. So you see, when you have Enoch Holdings Limited now taking over Gifford area road around Bema Camp, it's not being given to national security, it's not being given to airport, it's not given to the military command. Some ministry which even cannot house some of its offices is selling this to a private developer. If that matter came to your attention as a justice of the Supreme Court, should we expect justice from you?
Mr. Chairman, thank you very much. I'll look at it on the merit and apply the appropriate law to the case.
Do you drive around, you know, when you are from Elwak and you turn the underhead bridge around that area there?
I'll pray the honorable member to excuse me. Don't expose my...
I'll take you back to constitutional law. Do you also share the view that when you were mentioning jurisdiction of the Supreme Court, you introduced a novelty for me when you talked about the compensation jurisdiction of the Supreme Court? You want to explain that to me?
You let me look for the Chairman of permission.
So thank you.
The article 14.
At least I'm familiar with this original jurisdiction of interpretation applied from civil and criminal proceedings and those that you mentioned. But I was learning something when you said that when something is done, the Supreme Court may take a decision to be able to deal with those, to give compensation. 14, article, you are referring to article 14.
Give me some small time, let me look for it.
Okay, Chairman have helped me. Where a person who has served the whole or part of his sentence is acquitted on appeal, you don't think that the Supreme Court here is compensating for miscarriage of justice? Is that the question to you?
No, I don't think.
Then explain it.
Well, let me read the provision again for.
Thank you, Chair.
It says 7. Where a person who has served the whole or part of his sentence is acquitted on appeal by a court other than the Supreme Court, the court may certify to the Supreme Court that the person acquitted be paid compensation, and the Supreme Court may, upon examination of all the facts and the certificate of the courts concerned, award such compensation as it may think fit, or where the acquittal is by the Supreme Court, it may order compensation to be paid. This is another jurisdiction granted the Supreme Court to determine. This is
I've noted that, and I've learned that as an additional jurisdiction. That is not to justify the number of justices on the Supreme Court. I've seen people refer to civil, criminal matters, appellate matters, even the US, yet a federal system. We all know that each of the states has its own Supreme Court. But at the federal level, what number are you talking about? We have said, and this is not my first time, if you recall yesterday, one of our colleagues sitting here quoted Justice Atubuga when he said that at no point in time did we anticipate that Ghana will populate its Supreme Court beyond 14. At the time he was given a judgment in a matter which was before him. The Constitutional Review Committee made its own far-reaching recommendations. The overwhelming support was for a review of the Constitution to provide for a ceiling, but that's not for your purpose. Yours, the novelty is that if you were picked from the bar, or picked from the bench, or picked from the we will assume that you have been picked, as you yourself quoted Article 1282 of the Constitution. But having come to High Court, we thought that you were just beginning a career to match time. A match time at the High Court. And Chairman, it's a matter that we will take up very seriously as a country. You see, what we are saying is that let there be balance. And when we say balance, the balance can even be political, even with the idiosyncrasies that we all may look at. But the unfairness of not recognizing persons as a meritorious process of growing on their career is a matter for us to address as a country. We're not directing it at you, but yours were saying the novelty and the speed with which you are coming from High Court 16 September 2020, then tomorrow at the Supreme Court is what we're saying that yes, the President can appoint. But the President, when he's appointing, he shouldn't give us room for us to assume that he's creeping partisanship into the bench. That is a legitimate concern we've raised. And I now want your view on interpretation of Article 14 of the Constitution. But I'll leave it for you to comment. Thank you, if you so wish.
Yeah, but I only wanted to comment that I hear I don't know whether the honorable member feel hurt by it. I mean, this is a comment I want to have.
Or how can I be hurt by it?
Thank you very much.
I'm only saying that as Parliament we have a duty to hold the President to check, and we will do so religiously when the opportunity brings itself, as he's brought himself. And we're also now holding them in check, and holding in particular the President in check, that he shouldn't just expand the numbers at political expediency as his will, and that he should respect conventions and practices inherited as President of the Republic. So, young person, you are going to the Supreme Court. Oh, he's young. Muhammad's age mate, he's young, he's young. Mama, but he's young, he's young. He's young compared to others. But myself and Patrick Buama, when you read lucid judgment of justices of the Supreme Court, I'm concerned about the quality of judgments that we get these days. But fair to you, your judicial oath. Can we go to your judicial oath? I just need an assurance from you, which is to re-echo what the Honorable Samson Ahi requested of you. Can you recite the last stanza? I will truly and faithfully perform the functions of my office without fear or favor, affection or ill will, and that I will at all times uphold, preserve, protect, and defend the Constitution and the laws of the Republic of Ghana. What does the judicial oath mean to you as you walk further beyond the High Court to the Supreme Court? Thank you, Chair.
Thank you very much, Mr. Chairman. What it says is that you must, like the word speaks for itself already, so there's no explanation from there, and that is what you follow strictly when you're on the bench.
Chairman, may I now refer the nominee to Article 42, and with the same enthusiasm with which you interpreted 128, which qualifies you to go to the Supreme Court, provide some elucidation on your understanding of the ingredients in Article 42. Chairman, it reads, every citizen of 18 years of age or above and mind has the right to vote and is entitled to be registered as a voter for the purpose of public elections and referenda. What's your understanding of this provision in the Constitution? Thank you, Chair.
Well, my Lord, Mr. Chairman, sorry. Thank you very much, Mr. Chairman. Well, the Constitution, the Article 42, has given the minimum age by which a person can register and vote and exercise his franchise in any election.
So it says he must be a citizen of Ghana. How do we determine who a citizen of Ghana is? Thank you, Chair. Can you speak to that?
Mr. Chairman, the question again, I'm very sorry.
It says he must be a citizen of Ghana. Who is a citizen of Ghana? It's a question, Chairman, to the nominee. I said I want him to explain the ingredients in Article
a citizen of Ghana is a person one of whose parents or grandparents is a Ghanaian or was a Ghanaian. Among others, yes.
Is there no document that you have that I can refer to establish your citizenship?
Say it again, sir.
Is there no document that you can refer to? Which document gives me basis to refer to you as a citizen of Ghana?
I think the Citizenship Act itself has given the criteria for which a person will be determined as a citizen of Ghana. I think so.
So if I wanted to know who your father is or who your grandfather or mother or grandmother is, what reference document should I be looking for purpose of establishing your citizenship? Thank you, Chair.
Well, unfortunately, in the time of my father, there was no document, and they can only refer you to somebody he was giving birth together within a particular time.
In a year that it didn't rain,
yeah,
or the moon swallowed the sun.
Yes.
Anyway, I just want to say that this right, Article 42, by my view, gives meaning to the right to our democracy. When you made reference to your contribution to the MPP as an achievement, my colleagues here chose to weigh it their way. I'm weighing it favorably for you. At least you have contributed to Ghana having a democracy. If there were no political parties and functional political parties, we would not have a democracy. Is that right?
Mr. Chairman, if the honourable member may clap for me then.
Chairman, so my whip is saying that I should be putting closure and wishing you well and congratulating you well. But as I said, Ghana would need to review entirely its asset declaration regime. I strongly think that we must reverse the criminal burden when it comes to declaration of assets, because in Ghana, public officers still cannot account for commensurately how much we earn and how much property and resources we have, and all of a sudden we can't explain that. That's accounting for the eroding public faith in the elected. Even though I didn't like your comparison between an elected MP and the size of legislature when you refer to Article 93. Now, the right to vote. When the leader was on, you didn't have the courage to tell him to end. Because you know me, Chairman can persuade me. Chairman, I'm persuaded. After this, Chairman, I'm persuaded.
Mr. Chairman, thank you very much, and I share the honourable minority leader's view that the whole regime of the asset declaration has to be looked at. Thank you.
Okay. I remember there's an issue which we must deal with to clear any doubts. The Honourable Minority Chief Whip, Deputy Ranking Member, brought a document in which he claims that the cases the judgments you wrote as reported, and as reported are 7. And you said that there are about 70. Were there 70 in respect of judgments only, or judgments and rulings and others?
Thank you, Mr. Chairman. I said judgments and rulings. Judgments and rulings. The rulings are actually more, because those are determined not by taking formal evidence of somebody going to the box.
I see. Okay. Would you be able to give us a compiled list of those ones to clear our minds about the number of judgments and rulings and orders together?
Yes, very well, sir.
All right, good. Now, you submitted 2 judgments. I'm sure it was as requested by the clerk to the committee.
Yes, sir.
In suit number CJ or GJ 0635/2020, given on 6 July 2022. The parties named in are Stephen Kwabena Opuni versus Kwame Bafo alias Abronye. Do you remember that case?
Yes, Mr. Chairman.
You remember that? Do you remember the conclusion, the judgment you gave?
My Lord, Mr. Chairman, let me just check if I have a copy here. No, I don't have a copy here, but I think I give judgment to the plaintiff. Plaintiff, yes. Yes, it's all the defamation matter. Yes, it's all the defamation matter, of which I awarded some damages to compensate.
Don't answer me, don't.
So, my Lord, yes, the judgment went in favor of the plaintiff.
All right. And the plaintiff is Stephen Kwabena Opuni?
Yes, it's Stephen Kwabena Opuni.
All right. Is this Dr. Opuni the same as the Dr. Opuni who appeared or is in the news or was the Cocoa Board Chief Executive? Is that the same Dr. Opuni?
That is so, Mr. Chairman, from there.
Is Abronye the person who is currently the regional chairman of Ahafo, the Bono region?
My Lord, that is so, and the facts speak to that.
Very well. Okay. Right, but you gave judgment based on the law, not on the political coloration of the persons before you.
At all, Mr. Chairman. This is your turn.
But I have asked every nominee before me, all the Supreme Court judges who have appeared before us, or the nominees who have appeared before us, have complained that the workload is way too much. What do you think about that? Do you have any inclinations in respect of the workload of the Supreme Court?
Yes, I have before me here the annual report of 2017-2018 and then the 2018-2019. If you permit me, I'll refer to them and tell you the caseload of the Supreme Court. My Lord, in 2017-2018, number of cases pending, the Supreme Court, then in July 2017, 199. Then you come to the cases filed from July 2017 to June 2018, 624. Then number of cases concluded, 618. Then another 211 cases are pending for carryover. Then you come to 2018-2019, the Supreme Court, number of cases pending, 228. Number of cases filed from June 2018 to 2019, 539. That is a testimony of how loaded the court is. And then there's a need for us to find a way of how we reduce that workload for the Supreme Court. The High Courts where I sit, it's terrible.
Well, I practiced before the High Court, so I know the danger there. I was not very active at the Supreme Court at the time I left practice. So. But what do you think accounts for these huge numbers? The pending are the ones which they have had pending judgments, right? And the filed are new cases that are yet to be heard. Together, you're talking about nearly 3,000 in a year. Is that the case?
Yes, madam.
So what do you think, looking at the Constitution, that we can do to curtail the number of cases that go to the Supreme Court?
Well, Mr. Chairman, thank you very much. I've listened to the argument and listened to the debates, among lawyers, among the judges. When you look at the appellate jurisdiction of the Supreme Court, appeals from the High Court, the Court of Appeal in civil and criminal matters are as of right. As of right. So whether it's the case borders on precedent that has already been settled and whether settled law or not, and you file, the Supreme Court has to hear it, as opposed to certain jurisdictions. People are making a case of the USA. In the USA, they say it's no 9 days. The USA, pick and choose. At least 4 judges of the Supreme Court who have to review the case and see this case is coming. Oh, it's on this point of law. It's already determined. Then they treat it. Unless 4 of them have certified that cases, a particular case should be heard, they won't hear it. But here, excuse me, I won't use that language. No matter how frivolous the case is, the Supreme Court has to sit on it. Then there are situations where we are in a community. I come from Abuja, and then I've practiced all my life in the Volta region. I've done almost all the chieftaincy cases from all the communities. Then a case comes. I may not be able to sit on some of these cases. I definitely have to recuse myself. And that is why there's a need for some balancing and then for cases to be brought. So if we can look at the as of right appellate jurisdiction of the High Court.
Now, the report that was shown indicating judges, some have done 21 judgments, some have done 30 judgments. How long will it take to start a case, from your experience, from the beginning, through all the pleadings to the time you give judgment? About how long is the average lifespan of a case from the beginning to the end?
Thank you, Mr. Chairman. With the introduction of this witness statement thing, first of all, there's a lot we judges may not be doing at the application for direction stage. Sometimes the issues that are settled are just too many, and then some of the issues are not seriously contentious, but we still admit them for the trial. It makes the trial long. Cases that I was able to finish.
What is the average lifespan?
There are some cases within 2 weeks you should be able to finish, and then 2 weeks you should be able to deliver your judgment.
Since you became a judge, the cases you have started, which one has lasted longest?
I cannot immediately recall, Mr. Chairman. I cannot immediately recall.
Is there any that has lasted more than 2 years?
My Lord, there is one that is last, which is dead now. I'm doing it's taking so long. It's over 1 year.
Are there any that have finished within 6 months?
My Lord, even less than that. So some with the cooperation of the parties and the lawyers, you were able to finish in no time.
All right. So, in all, over your 2-year period at the High Court, how many cases in all have been filed before you or assigned to you, and how many of them have you done to the conclusion?
Mr. Chairman, when I went, if my memory serves me right, I had over, let me put it, not less than 200 cases. Some were added, and then it rose to about 600. But as Chief Justice later distributed some, but some were still brought. Did Mr. Chairman ask how many have I finished? If I'm not certain, that is why I need to clarify it from my secretarial staff.
Very well.
And be able to tell you.
So we will give you time to bring all those information.
Very well.
For that reason, we may not conclude your consideration today. But I think Honorable Minority Leader wants me to ask a question for him. He's finished, so I won't allow him. He says, what's the difference between allegiance and citizenship. Yes, owing allegiance to the state and citizenship. Yes.
Are they the same?
Well, if you are a citizen, then you definitely owe allegiance to your country of birth or your country.
So they mean the same to you?
Yes, in some contexts it will mean the same thing.
To you?
Yes, you.
That a citizen of Ghana will imply that you
owe
allegiance to the state of Ghana.
That is so.
And no one else. Yes. But you cannot be a citizen of another country and owe allegiance to a different country. Is that your understanding?
That is a bit debatable.
Thank you very much. We will suspend your consideration for today. Gather all your information. If you advise us when you're ready, we will then confer and give you a date to reconsider your nomination. Thank you very much. Thank you all for...
Mr. Chairman, may I make a clarification? In what form is it to be? I should bring all the rulings and the...
You have given figures, which is different from the figures contained in the report.
Oh, okay. Okay.
So we want evidence of your figures so that we can have a basis for cross-checking what has been put in evidence by a deputy ranking member.
How do that, sir?
So once, even if you get it tomorrow, just inform the secretariat. They will advise me. I'll confer with the leaders, and then we will give you a date.
I'll do that, sir. Thank you very much.
Very well. Thank you all for coming to support my colleague lawyers from Volta Bar, from Greater Accra Bar, and from the bench. We thank you for coming to support the nominee. You're discharged for now.
Mr. Chairman. Oh, yeah.